My lord, surface matter.
Surface. Call it at 2. Or we can call it tomorrow. Tomorrow.
Pardon, my lord.
Despite your lordship's direction, Lord, list this matter to it, Captain Lord. It has not been listed. They are going to fill up the post, Lord. That is the
Left the post.
lordship next week.
My lord, this is 6 months before registered fresh admission, and it is rolling indefinitely for 4 or 5 weeks since. So kindly
Listing.
Pardon, my lord. Pardon, my lord. Pardon, my lord. It is a surface matter. The petitioner earlier approached before this honorable court, and honorable court was also granted a
Listing.
no, my lord.
Then?
The authority not accept the EMI amount.
What do you want?
I want to direct the authority to accept my outstanding amount.
Phone.
No, my lord directed to me to
After listing the matter or what?
No, they have also issued another reaction notice. Yes, my lord, listing. Yes, yes, my lord, listing. My lord, urgent matter, my lord. My lord's order, my lord's order, my lord.
Next week, all right.
My lord, see, another notice also issued on Saturday.
Next week, all right. Can we have it next week?
My lord, item 201, my lord.
201.
Weekly list, my lord. Cover matter, my lord.
You said it yesterday. You wait. You have
Copy already solved, my lord.
You have said?
My lord.
We'll call it.
Your lordship, item number 19 in the weekly list. Read appeal number 540 of 2025. It's a covered matter.
Covered matter?
Yes.
You afterwards, after 12, you just mention.
Okay.
Okay. Both of you, whichever covered matters, na?
Okay.
Serve copy on the other side. If they agree with your version, we'll take up the.
Published.
All right.
Supplementary list item 1, WBC 23733 of 2024. Yes.
So, in view of the discussions made by this court before in the above paragraphs, the petitioner has failed to make out a case for interference under Article 226 of the Constitution, and in consequence, the writ petition is dismissed.
I agree.
Item 2, WBC 554 of 2026.
Interpretation have challenged the order.
Have that mic near you. Have the mic.
The
Mic, hai na? Yes. Keep it near you. Yeah.
No, you need not come to it.
You need not blow also. It works. Yes.
The petitioner have challenged the order passed by the Central Administrative Tribunal, Kotak Bench, Kotak, in OA number.
All right. So and so.
Yes, my lord. There, my lord, the fact of the case is like this, my lord. The OA was allowed, challenging the order passed.
Have you presented Rustomji's law of limitation?
Yes, my lord, that is ready. That was not available in the market. I have received it.
You have received that now?
Yes, my lord.
Have you presented?
I will present it.
You present it, then we will hear you.
My lord, it is there. I am undertaking.
That there is not the requirement. It should be presented is the requirement of order. You present it first, then we will hear you, not otherwise.
My lord, it is there.
Password.
I undertake, my lord. I will present it.
Makes no sense. Next. If is it ready now with you book?
Yes, my lord. I will have to bring it from my home, my lord. I could not carry it because it's a heavy book.
See,
Lordship, kindly
post this matter after the order dated 9/1/2020.
Your lordship may pass over. I will bring the book and submit it.
Pass over.
Pass over.
In the Sanskrit there is a shloka. Pustaka vanita vittam parahaste gatam gatam. Pustaka vanita, I need not say. Victim means money. If it is given to others, it has gone. Yeah, bring that book.
Yes, my lord. It was not available in the
Pass
packet,
over.
so delay. Otherwise,
Item 3, WBC 8404 of 2026.
Huh. But it is matter.
This matter is, my lord, the petitioner is seeking a direction.
14.
Second part of 14.
Second part of 14.
First part is to pass the order within 60 days.
Yeah.
Second part is to implement it, that is what the provision says.
Covered by judgment.
Covered by the judgment. Annexure 1, I have
Shall we issue notice? Returnable within 1 week.
parties. The borrower is not a party because nothing is claimed against him on merits.
The thing is claimed.
So
What is
lots
that
of
relief you
direction
want?
that relief is only to direct the magistrate to implement the order as per the judgment of coordinate bench of this honorable court.
Your Lordship, with the securitization application is also pending in the DRT, Your Lordship.
I mentioned
Why are you worried about it? Let the borrower be worried. So implement that order.
Lordship.
Petition prayer reads as under. First one. Already there is an order made under section 14 of the Surface Act 2002, under section 14 of Surface Act 2002 on
24 January 2025, annexure 2, page 21.
2020. First one. A copy whereof, comma, a copy whereof avails at annexure 2. First one. The text of the order is crystal clear, and it leaves no scope for any interpretation. First one. Next one. Learned counsel for the petitioner is right in telling us that the object of the 2002 Act is to effect speediest recovery of public money from the debtors when it is outstanding. First one. No. Therefore, he says, therefore, comma, he says, comma, there is a dire need and there is also a statutory obligation to implement the said order on a war footing. First one. We agree. Next one. In the above circumstances, petition having been favored, which a writ of mandamus issues to
Issues to the district collector, the OP number 1.
OP number 1 to implement section 14 order mentioned above within an outer limit of 4 weeks or 6 weeks.
4 weeks.
4. No, generally we have given 6 weeks. 6 weeks.
Not 6.
6 weeks. Without risking himself the contempt proceedings at the hands of this court for non-implementation. First, registry to send a copy of this order by speed post to OP numbers 1, 2, and 3 for information and needful action on a post haste. Okay. On post haste. Okay.
Item 5 is same.
Same. What is the order date?
That is 19 July 2024.
See, 19/7/2020. 24.
Annexure 2, 24.
Annexure 2.
Annexure 2, page 21.
10. All right. How many OPs?
The 3 OPs.
3 OPs. Okay. Same one.
Same.
Next.
I love it.
Item 4, 8446 of 2026.
Therefore, Mr. Senapati can be passed.
Also,
But, police.
next.
Item 5 has been disposed of. Item 6, WPC 8924 of 2026.
May please, please.
Yes, Mr. Karu.
This matter, my lord, involves an MSME. And your lordship have already passed certain orders taking pronate into view. This matter was before your lordships yesterday. Your lordships had been kind enough to direct me take instructions as to how much he can pay. My lords, I have taken instructions. Being an MSME, he's willing and ready to pay 30% by Thursday because the auction is on 30th.
Thursday.
Thursday.
Thursday is
Thursday is 26th.
26th.
30th is the auction. That's why your lordships.
26th. Thursday. 30th is auction.
30th is the auction.
We will say before 30th you should make, instead of saying 26. We'll give you 2 more days.
Because, yes, balance.
So that
Your Lordship may only, I'm grateful, but Your Lordship may only indicate that the demanded amount is at 110. It is 1,227,093.70. That's at page 110.
1 crore
2,27,903.70. I'll pay 30%.
30% will be how much?
Will be around
30, you pay 35 lakhs.
35
It will
lakhs.
be every.
It will be tall order, no? 31.
1 lakh will be more. That's all.
No, 31, my lord, because 30,
No, this date.
30% comes to, my lords, 30 lakhs some odd, my lord. 30 lakhs, 68,000 some odd. I have, my lord, let it be 31, because
30.
it's an MSME, my lords.
Heard learned senior advocate Mr. Kar appearing for the petitioner MSME. Personal. Petition has laid a challenge to the coercive recovery proceedings constituted under the Surface Act 2002. Personal. We had notice was issued earlier. No notice.
No, because my learned friend for the bank was on Agate.
Where is bank advocate?
He was here
Yesterday you were there?
We do not notice counsel for the KV at the bank in the court hall. We do not notice the presence of counsel for the KV at the bank in the court hall.
He was present yesterday.
Be that as it may. Next paragraph. The case has been made out for issuance of emergent notice and grant of reprieve, on bona fide being exhibited by the petitioner by offering to credit 30% of the amount in demand, that is rupees 1 crore, 102,27903.70 on or before 30th forenoon. First time. Denying reprieve at this stage may cause enormous harm. Petitioner, which is, as already mentioned, an MSME entity which enjoys certain protection and privilege statutorily accorded under the MSME Act. Well, can you give that name of the act?
It's the small, micro, small, medium enterprise development act 2006.
As has been voiced by a few high courts in the country. First one. Next one. One sentence. No prejudice should be caused to the lender in as much as even if the scheduled auction is deferred, the interest on the amount outstanding shall accrue due and go on accruing due. First one. Next paragraph. In the above circumstances, application in IA number 5421 of 2026 having been favored, the auction scheduled to be held on 30 March 2026 stands deferred sine die, subject to petitioner crediting 30% of the outstanding amount as specified above. First one. With a warning to the petitioner that in the event that this facility is not availed by complying the condition, not only the interim order stands rescinded, but the petition itself runs the risk of dismissal on that ground per se.
The auction sale notices at page 111.
Particular auction scheduled to be held on so and so. There is not wide auction notice dated.
The auction, its paper publication is 27th of February 2026.
26 copy whereof I will set annexed there.
Annexure, my lord, 17 series at page 111.
Next, 17 series,
At
page 11
111.
of the petition book. So structured that way.
May I pray for an urgent copy? No, sir?
Yes, sir. Yes, sir.
Greatly. Greatly.
Yes.
Item 7, CMAPL 285 of 2024.
Item 7, my lord. My lord, pass the order to submit to one law book, my lord, for the librarian. It is not available in portal of one, sir. Another book may be available.
Book is not available.
No.
Which book we mentioned, brother?
My lord, read jurisdiction of
Which
the
jurisdiction
constitution.
was by Justice B.L. Ansaria?
My lord.
It's out of print. Searching that book.
Okay.
It's out of.
You give writ jurisdiction from by Professor M.G. Ramachandran. Right. In terms of our order dated 2/2/2026, petitioner can, petitioner or opponent? Petitioner is permitted to present the book, writ, law of writs by Professor M.G. Ramachandran, instead of Justice B.L. Hansaria's book, as directed in our order dated 2/2/2026. Within 2 weeks. Within 2 weeks. Next.
Item 8, WBC 10636 of 2024.
What is this?
Advantage mistyped, corrected. There is a mistake in the,
Opposite party number, the name has totally been
What-
misplaced by some other.
instead of
What is the
Bhubaneswar
name?
Kochi,
Both the opposite
Rohit
party.
Kumar
Santuka.
Santuka. What it should be?
So this Supneswara Gochi, advocate RN9.
You have made that in the application you have said.
Yes, madam.
Application points out a short mistake in describing the OP in the cost title. First term. Application is supported by affidavit and learned counsel appearing for the petitioner, respondent, OP is right in telling us that name of the OP needs to be correctly described.
I'll make that advocate, madam.
And
Advocate's name also.
And also the name of advocate who represents ordered accordingly, and the petition is disposed of. Registry to effect the necessary change. Okay.
Item 9, read up.
Issue a free copy of the rectified order. Next.
Item 9,
Sorry.
read appeal 400 of 2025.
Item 9 is the matter, my lord, there, your lordship.
80,000.
80,000 rupees. That instruction I have immediately received. My lord, I had contacted with the local office of collectorate. They had also communicated the matter to the
To whom you have communicated?
collectorate office who is in charge of it.
Yes, it's in the presence of the chief secretary.
Also may issue notice to them so that
But here we expect that you should have talked to the chief secretary.
Chief
Because the
Secretary-
matter is being taken up twice.
yes,
And there is no point in taking the matter with the collector because collector has already recommended.
He
they have done. And the matter was placed before the
Secretary GA.
my lord, matter was placed before the chief minister itself. That is 100 lordship.
On which day it was placed? And what the chief minister said?
117 probably page. That is not so legible. This annexure 25, 117 page.
This is not legal.
It is, lordship may kindly turn to the last page.
What does it say?
121. It was placed and signed by the chief minister.
Saying, what the chief minister says?
My lord, nothing is
No.
legible.
ଦରଖାସ୍ତ କରିନ୍ତୁ ଆର୍ଥିକ ସାହାଯ୍ୟ ଯୋଗାଇ ଦେବା ପାଇଁ ମାନ୍ୟବର ମୁଖ୍ୟମନ୍ତ୍ରୀ ବିଚାର କରିପାରନ୍ତି। ଅନ୍ୟ ଦରଖାସ୍ତ ଗୁଡ଼ିକୁ ନାମଞ୍ଜୁର କରାଗଲା। Leaving these, others have been rejected, but this has been accepted.
With the presence of the chief secretary.
मान्यवर मुख्यमंत्रीको अनुमोदन निमन्ते गला भी सर
Nimante means
For approval.
for approval, yes.
For approval.
For also went there. Then chief minister has signed it.
there is approval by the chief minister.
Yes.
Yes.
On 28.
Still they don't want to give.
No, I'm not right. I am not aware.
On 28/4/21 itself. That's
Lordship may give me some time.
No.
Sir, Lordship may call this matter tomorrow.
No.
Tomorrow at least.
That will
Let
not
me
help
talk
you.
to the chief secretary.
Additional chief secretary has referred the matter to the director health and family welfare. Additional secretary health and family welfare.
Even if chief minister approves it,
My lord,
unheard of.
it is not legible, so that's why.
That copy has been supplied to us by a day.
But
My lord,
at the request of tomorrow.
tomorrow I will not be there.
You don't be free. We'll be here. In your absence also, your presence is not important. Money should reach your client
Yes.
because she is a widow. She has become widow. There being no money for proper treatment of the husband.
One day after.
Huh?
Tomorrow I will not be there.
You don't be here. Matter will come. Don't worry about it. We'll note your presence also. All right. If you want to say something, you can say online if you want.
My lord, I will be there in a
You have said already.
thread ceremony of my.
You go. We are not coming in the way. You go do that thread ceremony. It's important.
We'll take care of it.
Yes. Or evening around 3:30, can you do anything? Something?
No, my lord, I will hear none.
Call tomorrow. Yes. You attend. Don't worry. You have made your submission. We have already noted. You argued very well. In fact, we wanted to dismiss the appeal, but somehow you prevailed over us. Alright.
My lord, I have to. But they will counter.
We will not pass any adverse order in your
No, we will counter it. If anything they say, we will counter it.
Okay. Next.
Whatever I will say, I will be in your favor. Don't worry.
Or can we call this matter on 6th of April,
26th.
26th other bench,
No, 26th of this 25.
a day after.
Yes, ma'am.
Well, the day after will come. Okay.
Day after tomorrow I'll.
Yeah. Yes.
Item 10,
Well,
April 7 to 7 of 2025.
But so far as item 10 is concerned, but there is delay of 781 days. Besides that, this case is also covered by your lordship's order.
Just share that copy.
Yes, I have already given.
You have given. Mr. G, do you agree with that proposition?
Same.
Yes. Yes, my lord.
But
Yes,
you condone delay.
Yes, your lordship has condoned
Well,
it.
what is the explanation? Let us see. We will not dash to a condone, but let us see what is going on.
your lordship.
Inter-official communication. That has been deprecated by the Honorable Apex Court, your lordship knows.
That is Pritilada Nanda's case, my lord.
Yes,
correct.
This matter is.
And they have implemented around hundreds such matters in respect of similarly situated persons. And your lordship
This judgment was rendered in the light of that Meena Rani Mohanty.
Meena Rani Mohan.
Naraniman.
Your lordship may kindly turn to that bunch of bunch of orders, page 6, your lordship's order.
Yes, sir. That is
Similar set of facts.
This order will change. The order dated. Order. First paragraph as it is. Second paragraph is also as it is. Third paragraph you add. Added to the above, this intra-court appeal has been preferred after brooking a long delay of how many days?
781.
781 days. And an application supported by affidavit has been filed seeking its condonation. First off, a perusal of the application and the affidavit would show the parrot version of the appellant, which they have duplicated, presumably from other applications of the kind. First one. the interdepartmental interaction is no plausible explanation, to say the least. First, delay is too long to be condoned. First, then, in the above circumstances, see, so then this part is not. The impugned order of collected single debt shall be given effect to within an outer limit of 8 weeks. 8 weeks. Without by the appellant, without risking the possible contempt action for non-implementation. Right? This one.
Some more time may be given.
Yeah, 8 weeks you have given, no?
My lord,
3 months, all 3 months.
because my lord, there will be problem in seniority also.
Correct. Therefore, we have given 3 months. Then just bring it to my notice. Okay.
Item 11,
May I please?
WBC 20539 of 2019.
Yes,
May I please, Your Lord?
yes.
Well, order of learned tribunal, which is the subject matter of challenge in this case, is at page 20 annexed 3, ma'am.
Page 20.
Ma'am.
What is the matter about? Can you
The
make it within 3-4 sentences?
Yes, ma'am. That this matter relates to regularization of a casual employee, contractual employee, who continued from 1995.
Then you put the date.
Yes, ma'am. Right.
Get entry on which date?
17/5/1995, petitioner number 1 was engaged.
Petitioner 1.
3 petitioners are there.
That is
3 petitioners.
Petitioner 1.
The petition number 2 was engaged on 20th January 1995. And petition number 3 was engaged on 1st January 1995.
1993,
95, madam.
95.
Madam. 195.
all in 1995.
All in 1995.
Madam. They approached the Learned Tribunal for regularization of their case. The Learned Tribunal dismissed their case that they are not covered by Umadevi. Second ground, that he has relied upon one order of the Learned Tribunal. In similarly situated persons, they have approached the Learned Tribunal, and Learned Tribunal has allowed their case, and they stand on the same footing, same department.
Why is that discrimination it did according to you?
That they said their nature of appointment, our nature of appointment is different. But I, after dismissal of my original application, I filed a review, annexing all the documents, their appointment, my appointment,
Identical.
identical. And in one order, department has
All of them have been taken.
Yes.
Against one order.
and I have also brought to the notice of the Learned Tribunal. The department has also recommended our name. In that recommendation, my name appears with that person's.
Figures.
Yes, my lord. May I brought to my lord's notice that
Where is that recommendation? By whom recommendation was made and to whom?
for conferring temporary status.
That is not regularization.
No, my lord.
Default condition for regularization.
Yes, my lord. Department recommended for temporary status, giving us that was not worked out, for which 6 persons approached the Learned Tribunal. Initially, they approached my lords. Those matters are transferred to the tribunal. In 3 matters, tribunal allowed.
Followed means directed for.
Directed for
granting,
regulation. Directed for
granting
regulation.
Status.
Regularization.
Regulation.
Yes, my lord.
Where is that order?
Yes, I have annexed.
Just take us through that page number.
Your my lord, page number 47, my lord.
One second. Order of the tribunal CAT.
Yes, my lord. Yes, my lord.
Order is dated. Original order. OA number.
OA number, that is TA number, my lord.
CA number.
TA, transfer application.
From this court it was.
Yes, yes, my lord. That is 34 of 2009 at page 47, my lord.
4 of 2009.
34 of 2009. And 4 of 2013, 5 of 2013. 3 original applications.
5 of 2013.
My lord.
4 and 5.
My lord.
This is in your matter.
Yes, my lord. No, my lord.
In their
Earlier,
matter.
yes, in that case, I was the counsel. In other matter, I was not the counsel.
CAT order is dated.
Dated, my lord, 12th March 2018.
They granted temporary status and regulation also.
Yes, my lord. Your lordship, page 47.
47.
My lord, of my read petition.
Well, these persons were included in the very same notification, the recommendation.
Yes, my lord.
Same person.
I'll show my
Is
lord.
Annexed 2.
I'll show my lord. Your lordship can get it from.
Annexed 2 is the recommendation to the chief engineer.
Yes, my lord.
Request to confer temporary status in respect of casual persons engaged in different LP under TDMC diagram.
My lord, your lordship may see that page 18.
18.
My lord.
1-8.
My lord, 1-8. Your lordship may see.
Recommendation dated 28/7/2009.
Yes, my lord. Your lordship may say serial number 2. 4.
Your clients.
No, my client here my client is 3, 6, 13.
3, 6, 30. You are right.
And those who are in whose case
Regularized.
direction has been given for regularization, they are at serial number 2.
No, they are the very same person. In that list, your names appear.
Yes,
The
yes,
name of
Yes.
those who have been
Yes,
already
yes.
granted regulation also
There are-
appears.
yes. That their serial number I was just trying to show my lords.
2,
2, 6,
2, 6.
no, 247. Sorry, 247. And you'll also may see that just date of appointment, extreme right side corner. All were appointed in between 1995. Someone is appointed on 1/1, someone is 18/10.
July, something like that.
Yes, madam. All were appointed in 1995.
Mr. Party, anything more to say?
That I.
In the case, they all are contractual members.
Correct.
And they are not posted neither in the sanction post nor in the vacancy was there.
What about others who have been granted that status? We are not on other things. You can't be selective and sectarian in our approach to the employees. Those who are appointed on contract basis have been granted regularization. You have recommended. Where is the order of regularization? On the basis of this, tribunal made the order.
No, my lord. Tribunal granted them since they have continued for years together and relying on the judgment of the Uma Devi, my lord, tribunal directed to regularize them.
Where is that order?
That page 47.
That CAT order 12/3/2018.
Yes, my lord, page 47.
Yes, Mr. Party, what is?
In that part, I will take instruction, but I am just clarifying about the order. I gone through the annexure 3.
Yes.
The tribunal's order.
Yes.
And that tribunal's order is clarified. What is the status? This person they have cited upon to my lord that we are in similar status. They can't. Because they have been in our regulation, for what I remember, their status is in confirmed the temporary status to permanent status. Here is the case, they have engaged for temporary for some hours only. What happened is Dodosam, basing on the program wise, they have contractually engaged and they have disengaged. Because the closure of the LVTUT, they have their service closed. This is the submission by my side. If Lordship may give some time, then
Time. Right.
because the first time it was 90 matters, it is not admitted.
No notice was issued.
Yes, notice they have filed counter.
It has come.
He has filed the
Mr.
counter.
Party, if you do not
No.
read pleadings well and good, but read the court orders.
No, counter affidavit has been filed.
Yes,
Counter affidavit is also filed.
Regender is filed.
everything.
As per me, because that's why it is a case where this person proves us before my lord. I'm just reading this relevant person. Let's me come to the page.
No, we have three questions. Anyway, Mr. Party, we are in 227. Therefore, in limited supervisory jurisdiction, we are treating his matter now. How can there be a sectarian approach by the union government to the same homogeneous class of employees? They have been, kindly come to the recommendation. In recommendation, their names appear.
One side I'm clarifying. Even though they are engaged, there is no dispute that they have been contractually employed in the particular organization. I'm not disputing this. What I'm disputing, the status of the employee, those examples they have given now, and the present status is not equal. They are in different footing. These persons are in different footing. And because of the closure of the LPTV, that's why their service has been closed, because they are
Whether they have been continued or not in service.
No, well, they are continued till 2019. Till disposal of the.
Up to finish.
My lord, just I'm reading that. May I read, my lord? Para 7.
Yes.
Page 23.
Yes.
We have considered submission of perusal of the records and also gone through the tribunal's order dated 12/5/2018 in TA number 34 of 2009 and 4 of 2013 and 5 of 2013, which has been cited by the applicant in order dated 12/5/2018. It is under applicants in the 3 TAs are working the technical helper on the daily wage basis in Doordarshan Kendra, DDK, Bhubaneswar under such and such. 8. The respondents in the counter.
That only says the Uma Devi. 8 is Uma Devi.
The Uma Devi case.
Kindly see that thing.
Yes.
Which you want to read, you just glance. It is on Uma Devi. Uma Devi is not the last word on the subject.
Yes, para 8, I just.
Yes.
But the tribunal also cited a case of the Karnataka, which was confirmed by the apex court. That is that I'm just coming to para 9 minor. This is a very important manner.
Yes.
The facts of the present TA are different from the facts of the cited case of the Pradipta Kumar Das Supra. Since this TA, the applicants are admittedly contractual employees, and as stated in the counter, they are not engaged against any regular or vacant post. No such plea was taken in the cited case, as would be seen from the order dated 12/5/2018. The other difference is that by the order dated 13/11/2018, the copy of which has been enclosed with the MA number 379/2018 filed by the applicants, it has been decided by the respondents to close down the LPTV in which the applicants are working, and it has been decided that the contractual persons engaged at the LPTV are to be disengaged from 1/12/2018. No such order was placed before the tribunal in cited case of the Pradipta Kumar Das Supra. Hence, the cited case is distinguishable factually from the present way from which the order dated 12/5/2018 was not be applicable to the present way. Then, my lord.
No, then you need not spend time on that, because Tribunal refers to Uma Devi, ML Kesari, then Ish Rani. All they have been rendered almost insignificant after Jago. Thereafter, 3 more judgments have come. Of course, when this case was decided, they were not there, it's true. But law declared by the apex court is, unless stated to be prospective in operation, the apex court said in, which is that famous judgment, which Keshwananda overruled to some extent, State of Punjab, no? IC Golaknath versus State of Punjab. The apex court said, declaration of law by the apex court is always with retrospective effect, unless it is stated to be prospective in operation. That paragraph remains the law even to this day. That portion of the judgment is not tinkered by Keswananda. Rest of the things, yes. Therefore, the Jago does not say, hereafter this will be the regularization jurisprudence. It said if these facts do obtain on record, then the effect should be like this. This is how the judgment runs now.
But my lord, let's see the KL Kesari case.
Yeah.
It's a ML Kesari case.
Kesari, we have traveled much beyond Kesari, Kempu, Kesari, Vili, Haradi, Nili, Nerada, Uda. We have traveled beyond Kesari now. We can stay. Kesari is not the last word.
Really?
Yeah.
What I'm saying,
Jago, it has put the last nail on the coffin of your argument.
The last judgment is Pawan Kumar.
Pawan Kumar.
After Bholanath, then Pawan Kumar.
none of the judgment, according to my what I may be wrong also, none of the judgment has decided the person was working hour basis. Contractual basis is different. If a person has been taken, somebody has taken for a war, it is a exceptional war. Program basis, we are engaging somebody is taking 1 hour or 2 hours.
No, where is
Next day there is no war.
How many years?
Please there, my lord, that's fine.
How many years, sir?
It is a 2 months, 3 months, 6 months, like 1 year.
You were changing the person.
My lord.
Were you changing today ABC, tomorrow
Yes.
E?
Yes,
Is it?
because all the wars are supposed in news.
No.
Reading news.
Where have you taken up?
Right.
Where have you taken up?
If he is a daily wage worker,
Yes.
it is not that you are choosing them from the market and disengaging them for that particular day. These people who continue to work
From
maybe for
January,
1 hour,
July 95.
Night.
January, July 1995.
Till
Till 2019. They have been working.
I will be assisting to nursing give it tomorrow.
No.
But why I am saying so? Why I am saying it is a
Always
case will impact
Mr. Party.
in a different issue because
No.
it is a issue related to the Prasar Bharati. Nowadays, this technology has been developed. This service, they want the regulation service we can't utilize in any manner because they are not equipped with that technology, technically advanced. So the persons who have engaged contractually,
That's all. Allowed in terms of Jago and Pawan Kumar. 3 months for accomplishing the task of regularization and granting the other benefits. The concerns thereof. Yes.
Item 12, WPC 29757 of.
already
dispose of.
Yes, this one. Oh, yes.
Item 6.
Bank. Yes.
Coming from the Bhubaneswar, I have in the net. Where on appearance we will.
No, we have not mentioned. You have not. Not. Out.
Just mention his name. Okay?
May I please, Your Lordship?
Yes.
This is a postal assistant, physical handicap candidate.
Postal assistant,
Physical handicap.
my lord, I could not be ready to this
You want something? You want something? One matter he has argued, now he is tired. We'll have it.
What happened to apply the old council has gone, new file chair has come.
Week after next week?
Yes.
Call this matter week after next at the request of the DST. Finally. First of all, request for further adjournment shall not be entertained.
Date.
Next.
Item 13, WPC 26004 of 2022.
May I please, ma'am?
Yes.
This matter relates to engagement of solicitor on a particular scheme. My candidature was rejected on the ground that I have overqualified because I am possessing a qualification BA LLB man.
Yes, again, please repeat.
My candidate rejected on the ground that I have possessed higher qualification that is BA LLB.
That's why they have rejected my candidate, sir.
Where is that?
My that is also reflected in the input order, my
Sure.
page 63, my 63 of the long tribunal's order.
No, which is the latest judgment of the apex court on the ground that higher qualification.
My lord, that
cannot deny of anything. Which is that judgment?
Chandrasekhar Singh and others versus State of Jharkhand decided on 20th March 2025 in CA number 10389 of 2020. I have sent it for Xerox, man.
You give it.
I'll give it.
Take Xerox.
I'll provide that copy.
You give one. You have said already.
Only for Xerox. Lordship, I'll turn to
Where is it? Let us see the impugned order.
my lord, page 59, Annexure 14, passed by the Lord Tribunal in OA number 1017 of 2012, dated 29.
You have to look at us and you have to take us along the garden side. Otherwise, there will be no correct interaction. Yes.
Page 59.
What you had challenged before the tribunal?
I have challenged the order of rejection, my lord.
Where is that order?
Annexure 6, page
Annexure
29.
6, page 29. The Lordship can turn to page 30, that is internal page 2 of the speaking order, my lord. 30, my lord. Subpara number 3. From your biodata, it is seen that your educational qualification is BA LLB with the computer proficiency in ADCH. On the other hand, the
Overqualified.
Man.
For group D course.
Man.
3 grounds.
No discretion with the concerned authority. That is next ground.
My lords, but 3 grounds. My first and the second para, my lords, page 30.
No need of engagement of substitute.
Yes,
My lord.
earlier, my lords, the dismissal the way.
I have
They
filed.
challenged by that before the honorable court.
I have sought for information under the RT Act. They have considered and engaged 31 others in the review pendency of the original application and repetition matter.
51 persons are appointed.
Mine. Page 33, Annex 8, the information I. Mine.
Appointed as?
Substitute, engaged as substitute.
Substitute in group D.
Group D, mine.
Now, are they have been nomenclated as substitute or badali?
Substitute.
Substitute.
Right.
Under the idea.
May I pay mine? Lordship,
So the ground that we don't need your services is not true.
no.
That goes. What is your say on that?
My lords, there is where, my lord, running page 73, I am the reply, my lords, the annexure 8.
No, we are asking specific question. 3 grounds have been assigned in the order, so-called
Yes.
speaking order.
Yes, ma'am.
One is he is overqualified. That cannot be sustained because of the latest judgment of the apex court.
The order was set aside, my lords, this honorable court. Earlier, my lord friends challenging by this, they read before this honorable court. Honorable set aside, remit back the matter hard and actress, my lord.
Right.
Yes.
This order is set aside.
Earlier order, my lord, same, the higher qualifications, my lord.
But again, you have given the same reason.
No, ma'am.
Huh? Read that, which he has read, your friend has read, no?
Yes.
Please go.
Go to page 30, which one you read, brother? Page
Annexure
31.
6, my lord.
31. Why can't you have a small chip at your hands?
I have already filed a.
That's all right. But your memory is not that good.
Annexure 6, my lord.
You are flipping around now.
Turning the pages again and again, putting your
Page 30.
finger on the tongue and yeah.
This is the original speaking order, my lord. Impugn order.
Original speaking order is of 2012.
My lord.
That was set aside by the coordinate bench.
No, my lord.
It was not.
Only set aside the order of tribunal and remitted back the matter for adjudication. Man.
That WPC was
That WPC, they have my lord, page 54, man.
we are asking number.
WPC
not
number.
base number. WPC number.
3318-2018.
3318.
2018.
Disposed of on
12/7/2022, man.
2022.
remanding the matter to tribunal.
My lord.
On what ground remand was made?
Demand was made by applying that the matter reserved for more than,
On that ground, exceeding the maximum period of reservation.
as well as that a higher qualification is not a debar to for engagement of substitute, man.
What the tribunal says on that ground?
My lord, tribunal para 5, my lord. Tribunal gave a wrong finding, my lord, saying that RB number 137/2010 has been superseded by the Annex A by A, letter dated 17/9/2010, my lord. But both documents is one and same. RB number 137/2010 is of dated 17/9/2010, my lord. How can that observation can be given by tribunal? Page 63, para 5 of the impugned order, my lord. I am placing, my lord, that
Applicant was overqualified.
my lord.
This does not mean that the
Rejection was because the applicant was overqualified. Rather, the GM was in a position has specifically stated that appointment or substitute under discretionary quota of GM as notified under Annex A 5 dated 17/9/2010 has undergone
change.
by the RB number 137/2010. To that, your lordship kindly give Annex 1, my.
That is duplication, identical.
One document, my.
One document only.
Again.
The tribunal treated it as a different document. Subsequently, not like that.
Not. Annex A by 3, page 18, your lordship kindly give me glance.
A by 5.
A by 3, page 18.
Of the counter.
Of the writ petition, and they have also enclosed as count. Page 18 of my writ petition.
No, that is the order. That is the order of in WPC.
Page 18.
1.
Yes.
RB number 137/2010 dated 17/9/2010, my.
This very document is same.
Again. But tribunal says has gone changed, my.
Overqualification. Second one is change in policy. This is not true.
And there is no requirement.
Third is no requirement.
My.
But they have taken
34, my lord,
31%. 34%.
34%.
What do you say?
My lord, page 73, my lord's para 15 of the my counter.
73.
Yes, ma'am. Running page 73, ma'am.
3, please.
Well, that the reply amendments in para 10 to 12 of the writ petition. East Coast Railway provide employment to the eligible person following the guidelines circulated by the Railway Board from time to time. No discriminatory policy was adopted in this case, and no false facts were submitted railway as alleged by the petition. It is humbly submitted that the persons who have been engaged as substitute were eligible as per board's guidelines as stipulated in RB number 137 of 2010. The petitioner's case was not considered by the general manager under his discretionary power. Discretionary power which was vested with the general manager was.
No, it is not there.
Yes. The nature there is no, this cannot be claimed as a matter of the right. Hence, the discrimination and violation of the articles does not arise. Recruitment/engagement is done in railway as per the board guidelines only.
But same guidelines.
Same guidelines.
The tribunal proceeds on the assumption, wrong assumption,
Yes.
to say the least, that guidelines have undergone change. It is all part of the very same document. That is number one.
My lord.
Number two, the tribunal gave only lip service to the first ground, that he was overqualified. That ground was altered by coordinate bench.
There is set aside, my lords.
Yes.
Yes.
That being the position, tribunal should have said that ground does not avail for you. Number two. Number three, you say which engineer it is. That engineer has no discretion, etc.
GM.
No,
General manager.
General manager.
The father, actually, the petitioner's father was servicing the department of the railway, my lords. So then, my lord, 74, my lords, page. Nothing had been explained in forwarding the letter as to why only the application of Sri Jyotiranjan Bhalyar Singh, son of Surendra Naik, the then divisional personnel officer of the Sambalpur division, was forwarded to Secretary to GM, East Coast Railway, Bhubaneswar. The petitioner is demanding his recruitment as because some other candidate got recruitment and just his application was forwarded by his fathers and vacancies are available with Railway Board instruction stipulated RB number so and so. Is very clear in this regard. This is not sustainable in the eye of law and denying his recruitment cannot be treated as unconstitutional.
Huh? His father was working there.
No,
Maybe his grandfather also. How that will come in the way of he is just taking the claim for appointment? Well, which rule says if father is employed, son cannot apply? Where is such a rule? Where is such a policy statement by the railways? Eastern Railway. You should go back to Western Railway.
Yes.
What is that attitude? What kind of overqualified? Therefore, you are not. Less qualified, therefore, we will not give you appointment. What kind of stand we do not, less I can understand. But overqualification, how can that be? No?
No, but
And that was set aside by the coordinate bench. Even then the tribunal glosses over the issue. No, we are allowing this matter.
My lord, the petitioner is overage, my lords.
Overage.
50.
Or is it because of your fault actually?
No, my lords.
No, then why did you deny the appointment? You pay some damages maybe as a recompense. We have that discussion where the industrial tribunals matter within that famous judgment. Courts can mold the relief depending upon the changed circumstances. We have passed one order, one such order we have passed. Waiting. Yeah.
No, my lords, taken next week.
No, nothing like that. We are against, we don't do things on installment pay. We are not a bank.
Yes.
Kindly be seated. Go to the impugned order. This petition filed essentially under Article 227 of the Constitution of India, other companion provision, namely Article 226, having been ornamentally employed, seeks to call in question the Cuttack Central Administrative Tribunal's order dated 29/8/2022, whereby OP's petitioners OA number 260/0001017 of 2012 has been negative. Personal. In the said way, petitioner had called in question the order of the OPs in denying engagement to him, essentially on the grounds that he was overage, semicolon. The policy guidelines have been changed, semicolon. And there was no requirement of services of anyone, much less the petitioner. First, kindly be seated. Next paragraph. Learned counsel for the petitioner submits that the first ground as to his client being overqualified was faltered by a coordinate bench of this court in earlier round of litigation, that is WPC 3318 of 2018, disposed of on 12/7/2022, whereby this matter was remitted to the tribunal for consideration afresh. 7. Despite that, the tribunal did not, a tribunal glossed over the issue, and that constitutes first infirmity on the face of the record. First. Secondly, he submits that there was no change of policy guidelines, and the tribunal grossly erred in holding to the contrary in paragraph 5 of the impugned order. And thirdly, the tribunal blindfoldedly accepted contention of the OPs that there was no requirement of services of anyone, much less the petitioner. First, he draws our attention to the RTI information which his client has pursued at the hands of the OPs, to the effect that pendently as many as 34 persons were engaged in Group D as substitutes, and therefore the impugned order is liable to be voided. First, learned CGC, are you a
Senior panel counsel.
senior panel counsel?
A.K. Roy.
Learned senior panel counsel appearing for the OPs with equal vehemence made submission in justification of the impugned order and the reasons on which it has been constructed. First, he repeats that the policy guidelines were changed and that there was no requirement of services of the petition. First time, he turned the pages of his papers in undertaking this exercise. First one. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are trying to grant indulgence in the matters as under for the following reasons. Number 1. The claim for engagement, that one more sentence you have read. Learned panel counsel tells us that now the petitioner, having been overaged for employment, no relief can be granted in the changed circumstances. First, next one. Having heard side society, we are inclined to grant indulgence in the matter as under and for the following reasons. Number 1. The first contention of learned counsel for the petitioner that no citizen can be denied the benefit of employment, public employment, or the largest only on the ground that he is overaged has to be accepted in view of declaration of law by the apex court of the country wide. You get. This is reported now. It's not reported. Not it reported.
No.
Reportable. Wide civil appeal number 10389 of 2024 between Chandra Shekhar Singh versus State of Jharkhand, disposed of on wide order dated 20 March 2025. First one. And the coordinate bench of this court in WPC 3318 of 2018, wide order dated 12/7/2022, had faltered the very same ground which the tribunal had earlier assigned in denying relief to the petition. First one. That being the position, the tribunal was not expected to gloss over the issue. And therefore, as rightly submitted, there is error. This is the first error apparent on the face of the impugned order. Which needs to be set at naught by us. Number two. The second submission of learned counsel for the petitioner that there was no change of policy guidelines which governed the engagement of services of persons of the kind again needs to be countenanced in as much as the tribunal misconstrued the documents as being different from the earlier ones when they were one and the same. First off, this could have been ascertained just by turning the pages of the same document that were produced in series. First off, therefore, the second lacuna in the impugned order is demonstrated. Next point. The last contention that there was no need for the services of petitioner at all, and therefore no relief could have, and therefore the tribunal rightly denied relief to the petitioner cannot be accepted. Because during the long drawn legal battle, as many as 34 persons of the kind have been engaged by the OPs, which fact is vouched by the RTI answer. RTI answer. A copy whereof I will set annexure.
Annexure 13, page 58.
Annexure 13 of the petition. First of all, brother, do you deny that? That information which he has received, do you deny
My
that?
lords, the petitioner not apply any, my lords, the post only the.
No, assuming
Yes,
that XYZ does apply.
Yes, so as per the policy guidelines, the up to 34 employee all appointed, my lords. The petitioner not apply in.
The contention of the learned senior panel counsel that the said RTI was not at the instance of the petitioner.
The Shankar Valia Singh, RTA registration number.
No, he only has.
He only
stated
has.
of-
On 12th,
It is-
22.
It needs to be noted that this document being part of the record has not been disputed by the other side, rightly. Right. First one.
31.
31 candidates.
31.
Yeah, that's what I had written actually.
31.
Changed my 34.
31.
31
Yes.
candidates. Okay. Next paragraph. All the above being said, now the relief as sought for by the petitioner cannot be granted to him because he has turned to be overaged. First time. That does not mean no relief can be granted by this court in the changed circumstances. And petitioner not being responsible for that. First off, time and tide wait for none goes the same. First off, if a litigant is prejudiced because of the pendency of the litigation, the court has to do some justice on the principle of ex dubito justitiae. And an argument to the contrary would result into genuine, scrupulous litigant losing faith in the judicial process. First of all, in matters like this, some monetary compensation would undo the injustice. First of all, in our considered view, a sum of rupees 5 lakh, if paid to the petitioner, injustice done to him can be undone. at least to some extent. First, we have taken such a view in the case of so and so. Just find out that judgment. Judgment of after all standard books on jurisprudence, including the one by Amartya Sen, a theory of the idea of justice, supports this view. First, in the above circumstances, this petition succeeds in a different form. First, a writ of certiorari issues quieting the impugned order of the tribunal. Semicolon. Petitioners OA number so and so having been partly favored. A writ of mandamus issues to OPs. Which OP?
All the opposite parties.
All the OPs. All they should take 5 lakh rupees each. We will be very happy to do that. One. Eastern Railway.
GM is
OP number
1, my lord.
To pay to the petitioner a sum of rupees 5 lakh. 5 lakh. Within 8 weeks.
3 months, my lord.
Why 3 months? Are you going to mint the money or what? He is available in the treasury. 8 weeks. 8 weeks. Failing which, the delay, if brokered, would carry an additional levy of rupees 5,000 per day. 1,000 rupees per day. 1,000 rupees per day for the first 30 days and 500 rupees per day for the first 30 days and rupees 1,000 for the days next following. First, the additional levy component shall be recovered from the erring officials of the department personally. Okay. Yes, next.
Item 14, WBC 24210 of 2024.
Item 14, my lord, I refer short adjournment, my lord.
You want short adjournment? 2022 matter.
24 matter.
24 matter.
24 matter.
My lord.
You are
Covered
matter.
Yes.
covered by judgment.
Covered. I have given the judgment.
No, we will not. Give that much first shows. Whether it is covered, wherever covered, we are not giving any time at all. Otherwise, no citizen will be happy with the court. Already they are unhappy. Don't want to escalate that level. Show the similarity, brother.
Yes, but this is following this main judgment on first case.
Huh?
Here, my lord, the appointment of fact mechanism. Here the para 6 of that judgment. Here the benefit of the pension rule and the inclusion in the GPF rule was denied only because the petitioner in that case joined in 31/5/2010. After that cut-off date 1/1/2005.
How can he be allowed?
Again?
How can he be allowed after 30?
Because the advertisement of the process started prior to that. That is the ratio decided.
But when did they join?
Joined in 31/5/2010. Because that cut-off date was
Date of
1/1/2005.
Date of appointment of the focal point.
No, the law laid down by the upheld by the Supreme Court of this Hon'Ble Court judgment in Ananda's case that even if the process started prior to 1/1/2005, appointment made after that 1/1/2005,
No,
their
but
service
because-
condition will be guided as per the rules.
Cut-off date is there for you.
No.
Cut-off date 1/1/2005.
1/1/2 correct.
2005, that is the date.
2005,
Is the
but notification was on in September 2000.
17/9/2005. Correct.
That is how-
17/9/2005, that is why it was granted. And in this particular case, my lord, the first judgment, following the Ananda's judgment, that in Manas Sau's case, what I have given in the past, there the coordinate bench has said, even if it is 31/5/2010, after that amendment, they are also entitled to the benefit of the old pension rule because the process started prior to 1/1/2005. That is the judgment. These are the two orders. And following that judgment, my lord, many other cases passed by the government also.
Many cases are passed by the government.
Yes, many in the government. This is in the High Court and Judiciary. And Ananda's case is of our own High Court. And this Manas Sahu is of other departments of the government. That has also been accepted by the government in many cases. Well, if my lord permit also, I can file some document also accepting that provision. That cut-off date, my lord, is following from my lord, thus now that 17/9/2005
Right.
amendment date,
Correct.
that has been diluted by the authority themselves. So that last is significant. Those the appointment order I can give. Yes. And our judiciary also.
Let us see.
File.
Turn up to 2 weeks at the request of the DAC finally. Yes, next. God, you know, say. It should keep it in place. I'm not going to. We will be reverting it, huh? Upon seconds.
আনন্দ স্টেশনটা পড়ে যেটা যেহেতু সে জয়েন করেছে ইভেন আনন্দ আসলে এটা প্রসেসটা আরো বাইরে কয়েকদিন করতে গেছি এখন চিফ কিছু বললি আনন্দ তার প্রাইভেট সেক্রেটারি গরি করে দিয়েছি বলে আমি কেনা হচ্ছে ফেভার পাখি হবে না রোলটা চেঞ্জ করতে এখন প্রসেস যদি একবার আরম্ভ হয়েছে তাহলে এই যে 17 will not apply 17 হবে না কিছু করে ফেলি 17 এবং রেট্রোস্পেক্টিভ এটা যে করে ফেলে প্রসেস যদি পূর্বর আরম্ভ হয়ে যেত কিন্তু সেটা প্রসেস কোথায় সেটা সে ওটা আগ্রহ দিতে যে যদি প্রসেসটা পূর্ব যেতে হবে 17 পূর্ব সেইটা আছে আমার তো জয়েন করছেন একটু প্রসেস আরম্ভ হলো এটা তো রেসিও করে আনন্দ দাসকে পড়া সাথে রেশিও হলো ଅଧିକା ଗ୍ୟାପ ରହିଲା ସେଇଟା ବି ଦେଖ ସର୍ଟ ଗ୍ୟାପରେ ଆମେ এটা প্রবলেম করছো
Your Lordship, you may be pardoned. Your Lordship told us to mention at 12 o'clock.
Covered matter.
Yes, yes.
Come on, guys, need to fit. Give that. Brother, whether it is covered or not, just look into. In covered matters, kindly not ask for adjournment. If they are covered, they are covered. But only thing you have to demonstrate that it is covered. Give that.
Already the judgment given to
Not to us.
Yes, yes.
My lord, it's a weekly matter.
Weekly 90.
Matter. But we have been following this practice. Even in the weekly matter, if matters are covered, we are simply saying covered by judgment. And therefore,
What matter, my lord, they have come before your lordship in a narrow compass that after the main judgment has been passed, whether the IU was maintainable or not. Because they say that the honorable judge became functus officio, therefore no further order could be passed, modifying the main judgment. That was their contention for which they are before your lordship. And now they want that it's a covered matter. That is the narrow. My lord, I take your lordships. Only one adjournment to examine the matter, my lord.
need to examine. Because it runs into pages.
Yes.
Let him examine.
Your
We'll
Lordship,
call it tomorrow. Just
Tomorrow.
your Lordship, government already acted upon it.
Yes, I will examine and
Give that copy.
Okay, let it come in the supplementary list.
Tomorrow we will give it.
Okay.
Supplementary list.
See, shift it to the supplement. Okay. Which is that? That again is covered. If it is share, have you shared the copy?
This is your judgment.
Who appears in this? Other side, Mr. Apanda?
My lord, it is an item. My lord, 201 matter has not been allotted. We have not been.
50.
Yes.
Daily list. Tomorrow. Yes, next. Yes, brothers.
Item 15, WPC 2974 of 2025.
May I please, Your Lordships? Your Lordship, I'm appearing for the petitioner who's the auction purchaser of this instant matter. Your Lordship, I'm ready with the arguments.
You are ready?
Yes, Your Lordship.
Any urgency in this matter?
Your Lordship, we have bought the property in the auction, but a stay has been granted by the learned DRT, because of which we are not getting the possession of the property, Your Lordship.
Main matter is still pending.
Yes, Your Lordship.
We'll direct the DRT to dispose of the main matter in 3 months.
Your Lordship, I have prepared how it can be dealt in before this honorable bench, Your Lordship, and how the honorable Supreme Court has also favored in the fact that the honorable High Court has the power.
No, we have power is true.
Yes, Your Lordship.
We have power.
Yes, Your Lordship.
Coextensive with requirement is one thing.
Yes, Your Lordship.
But when DRT is examining the matter, why we should allow you to invoke our power?
Your Lordship, because the DRT up till now has been gravely making decisions beyond their jurisdiction, violating.
We will tell them, we will fix the parameter and decide the matter.
Your Lordship, can I just make one submission, Your Lordship? Yes. The section 17 that the opposite party has filed, it is of 2 years delay, Your Lordship. The possession certificate under section 13(4) was issued in 2022. Now the opposite party is claiming that we had absolutely no idea that this possession certificate existed, the demand notice existed.
All this DRT will tell BDRT to examine this also.
Your Lordship, but the DRT is not taking this into
No, we tell them to
consideration.
take up.
That they did not have the power to condone the delay, Your Lordship.
You put that contention before the DRT. We'll have the benefit of DRT's version.
May I assist your lordship, my lord? I am appearing for the bank, my lord.
Bank.
The difficulty is here, my lord. The interim order was passed after my filing, my lord, by way of a memo, the sale certificate issued. And the recorded, the third party interest has been already by that time, my lord, already.
All these contentions can be examined within the conspectus of section 17.
Yes.
This is what Justice Chandrachud,
Yes.
Justice
That's true, my lord. Only, my lord, I am apprising your lordship that despite my lord bringing the notice to
One
the
second. We have the object of establishing a statutory tribunal.
Yes.
Is to exclude ordinarily the exercise of rich jurisdiction by judges like us.
Yes.
Once that is looked into, then this is how L. Chandrakumar is shaped.
Yes, ma'am.
97 Supreme.
Yes.
Is it SP Sampath Kumar 85?
Thereafter L. Chandra.
L. Chandra Kumar, several, the Tangabalu, all they have been. We are adopting that jurisprudence here.
That's correct, Melody.
Okay.
1, 2, 3 lines if I showed to your lordships from the impugned order.
No, that is there before the DRT.
That is there, my lord. And
Main
it's now
matter is
posted.
before the
Now posted to, yesterday it was there, my lord, and now posted to 21/5/2026.
Take note. What do you say?
Well, it is ready for hearing, it can be disposed because
You are
of.
not supposed to take one single adjournment there.
No,
But the my lord,
I
petitioner
understand.
has not been made a
We
party.
have not made a party, your lordship.
That is the whole trouble, my lord.
I'll take my party by the next day.
And your lordship, it has been continuously prayed by the
You are not a party there.
No,
I'm a petitioner. I am the auction
He
purchaser.
is
Auction
not,
buyer.
because of the stay granted by,
Auction buyer.
I'll make him, I'll
Okay,
make that,
direct the DRT to array your client
well,
as a, what do you call, respondent or opponent? What do you say?
respondent.
Respondent, as respondent. All right. Do we want an order to be fast on merits, or we can say all of you have agreed? Therefore, with our suggestion, you agreed. We direct the DRT to take up the matter and dispose of it within an outer limit of 8 weeks. All contentions we are keeping.
And
Will
the
it be
matter,
all right?
well, only thing, my lord, matter is posted to 21/5. It can be advanced and.
We'll say that alone. Petition prayer reads as that. First, petition is by an auction buyer of a security property in the process constituted under the provisions of Surface Act 2002. First one. The grievance is against the interim order granted by the DRT Cuttack in pending essay number
69 of 2024.
69 of 2024.
24.
First one. Next paragraph. All the learned advocates graciously agreed with the suggestion of this court that petitioner be arrayed as one of the respondents to the pending essay, and that the essay be finally heard and disposed of by the DRT with the participation of all the stakeholders, preferably within an outer limit of 8 weeks, comma, all contentions for that purpose having been kept open. First one. Ordered accordingly, and writ petition is disposed of.
Your
First
lordship,
one. The respondent borrower, OP borrower, OP borrower shall move a formal application before the DRT for impleading the petitioner herein as respondent as mentioned above on a work footing, and that the bank shall not object to the said petition. First.
As far as bank is concerned, we have already filed our counter.
can I just make one prayer? There is a stay that has been granted by the learned DRT. That stay was granted in our absence, your lordship. If that stay can be removed.
No, cannot. We all contention. That would be all contention. All contention. Actually, the right course is you should get impleaded before the DRT. Then you should say vacating of the interim order. Read 1958 Supreme Court. There is one judgment, very beautifully written judgment on this issue. All right, that is the right procedure. Yeah.
Much obliged.
I believe that was within the 1958, which spoke of proper necessary parties. 58 Supreme Court. Okay. Rajia Begum versus Shahnawaz Begum. That judgment. Next.
Item 16, WBC 3184 of 2025.
Yes.
Please, my lord.
Yes.
My lord, here, my prayer is that to provide the electric supply connection to my premises, because I applied for providing the electric supply. They have verified
they have accepted, executed an agreement. Thereafter they say no, because unless you have to obtain a no objection certificate, we cannot provide the
No objection from whom?
no objection from that from the concerning executive engineer. What he said that there is some
Impugner. Let us read the.
sir, Annexure 1. Sir.
You not for the
My lord.
electricity supplier?
I am supplier for opposite parties.
Yes.
Fact that, may I clarify one?
Yes.
Clarify the position. He sought for a new power supply connection.
Huh?
He sought for a new power supply connection to
New
his,
power supply connection.
to his premises. That was refused because there is an area outstanding pending against his father of 2 lakh some odd. No, your father. Please let me some. Your father, that 2 lakh some odd amount that was pending. He made a repentation and that was refused. Against that, he moved to the grievance redressal forum under section 42(5) of that Electricity Act 2003. A grievance redressal forum says, since that there is a dispute with regard to disconnection of power supply because he has not applied under regulation 110, he has to, if he wants to disconnect power supply, he has to submit an application to the licensee that power supply to be disconnected. His father did not. Because of that has been exactly clarified by the GRF and hold that after April 2014.
To the very same premises cities.
No, that is different.
That is
in a government land. That is in the government land. On Hato is there. They have not installed any meter. Sir,
We asked
the lordship that GRF hold that after April 2014 there will be no demand to the petitioner and to revise the bill accordingly. Being dissatisfied, he moved to the ombudsman.
See, electricity apex court said is the lifeline of people nowadays. Without electricity, without gas, it's very difficult for us to survive. Difficult, not impossible, although. So, in rejecting application for supply, apex court said in 2 decisions, the court should be very lenient in examining the matter on merits. Okay? Because it's very essential. It's the lifeblood of the people. Now, suppose if father is due or grandfather is due, unless you invoke the doctrine of pious obligation, how can you hold the son liable for that?
In fact, that is the statutory provision.
Which what the section?
That's section 17.
Read. Does it say son should pay for the debts of the father?
Your Lordship, I'm reading the same. The regulation 7.
Read. It texted.
If the applicant in respect of an earlier agreement executed in his her name or in the name of his spouse, son, daughter, parents, or in the name of a firm or company with which he she was associated with a partner, director or managing director, is in area electricity dues or other dues for the same premises or his her other premises situated in the same discoms or any other discom in the state, the application for supply shall not be allowed by the engineer until arrears are settled and paid in full. That is,
does it say so?
No, that is the regulation that has been framed by Regulatory Commission.
Where does it? How do you read? For father's arrears, son should pay. How can you fit it into the text of that regulation?
That his parents, the area outstanding is
Has he secured the power supply in the name of parents by him? It is.
Yes.
Suppose if the father and children are not in good terms. Father draws electricity supply and arrears are in lakhs. He wants to ensure that the son should be in darkness. I'm giving a hypothetical example. That may not be. Okay. You mean to say for son should pay for
that is the statutory regulation.
No, that is not like that.
And apex court also held in Kesinanan versus State of Electricity.
Let us see. Except in Hindu law, which mains on Hindu law discusses, unless,
in fact,
listen to us first. You are not in a position to listen because you don't want to know law. Law.
I have
best authors on Hindu law, like Main Hindu law, Mullah's Hindu law by Raghavacharya, one of the famous books in South India that is very often referred to. And the son is liable where he inherits the property of the father. That is doctrine of Rosenthal. Okay. It is not your case that he has inherited any property from the father, parents. Number one. Son will be liable. Mitakshara says, Hindu Mitakshara, text of by Vijnaneshwara, commentary on the Adjournment Smriti. He says, son shall be liable for the debts of the father on the ground of pious obligation. Where is that obligation is incorporated in your rule? Let us read your judgment. Which is that judgment? Give us.
That judgment was particular case.
Give us.
Miller.
We'll read the judgment.
In fact, one copy my head.
What I should do?
Sir, can I clarify the position?
Apex court held.
Within a minute, sir.
No, judgment, have you read the
Judgment is there, but only to clarify how they are claiming.
judgment? He wants to clarify. Have you read the judgment?
No, not judgment, sir.
Don't clarify without reading.
Sir, no. Factual aspect I am telling. Factual aspect. What is
Unless you read.
Sir.
Let me comment.
Kind of argument.
After he
Sir.
after he
Nauseating.
after he lost his case before the GRF ombudsman, he is
You are not
committed.
giving the judgment and you want to go on arguing. We'll say that you should be depaneled from the electricity board. What is this kind of argument? Where is the jurisprudential support to the judges? All substandard arguments, we feel like taking bath after hearing your arguments.
The last page, your lordship, can that be finding all findings. There is lordship. The conclusion are summarized.
Page number?
The last page, your lordship.
Paragraph
Last
number?
part 129, 329.
329. Let us read.
The conclusion are summarized below.
Which subpara more aptly to be looked into?
The duty to supply electricity.
No, you got it from A.
That is
A.
Millard. The duty to supply electricity under section 43 of 2003.
It is subject to compliance. Go to the next point.
Millard. But subject to compliance, your lordship. Then your lordship kindly have glance. E, lordship, E. The scope of regulatory powers of the State Commission under section 50 of 2003 Act is wide enough to stipulate conditions for recovery of electricity areas of previous owners from new or subsequent owners.
Previous owners and
Subsequent owners.
But structure is the same. Brother,
Millard.
structure, the building is the same. Owner changes. Therefore, there should not be fraud on the board. Therefore, they said, for the same structure, if you want supply, you have to finish off the arrears, pay off the arrears.
Millard.
Only then it will be. But that is not your case. He is a fresh, he has constructed a fresh building now.
That is a fresh building. I don't dispute on the that he made a fresh building.
Sir.
Let me complete. Your lordship kindly glance. G, your lordship, the G.
G. The rule
The
making
rule
power
making power on
contained
section 181, read with section
Provide for
50 of the
statutory
Act is wide enough.
plenary statute providing for creation of such charge. Correct.
And I am coming to your lordship that the regulation that State Commission in exercise of 18150, he has made the regulation that the previous.
Give copy. Give at least our Xerox. Our Xerox machine has become very active nowadays. Since you do not bring any
In
copy.
fact, that is in the book. That book is there.
No judgment.
No, are you showing the judgment or regulation?
I am showing the regulation. That judgment I am supplied your lordship. I am showing the regulation then.
The judgment is okay. Judgment is there.
Judgment is there. It does not take your case further. It only broad guidelines, power to delegated legislation, etc. Nothing beyond that. Which is the regulation?
Is
Get to Xerox of
high
regulation now. Give that book to them. We have that.
Yes, sir.
Yes, give that.
552.
525.
No, 552.
regulation?
17 Roman I, your lordship.
Since the applicant in respect of an earlier agreement executed in his or her name or in the name of his spouse, son, daughter, parents, or in the name of firm, he has not executed on behalf of the parents at all.
But he was a member of the,
That does not say. That is not the text of the rule. Rule you have to read as it is.
Then your lordship,
Rule is made
Miller,
where he procures the supply
Miller,
by making an application in his on behalf of his parents.
Miller.
Then he is liable. That is the text of the regulation.
Then your lordship can, or in the name of firm.
Correct.
Company with which he oblique she was associated either as a partner,
Correct, brother.
director or managing director, is in area electricity dues or other dues for the same premises.
But
Or-
not the same premises now.
I'm coming, that is other premises also.
Okay.
Or
his
his
or
or
her
name, other premises,
situate in the same
same discom or any other discom.
Discom is
Discom is a TP nodal, the same discom,
same under the same agency
same as same licensing.
license.
or any other discom in the state. The application for supply shall not be allowed by the engineer until the arrears are settled and paid in full. Kindly read again, slowly. I will read for your purpose. If the applicant, in respect of an earlier agreement, executed in his or her name or in the name of his spouse, son, daughter, or parents, or in the name of a firm or company with which he or she was associated, either as partner, director, managing director, is in arrears of electricity. He should be a party to the agreement. He should be associated with the agreement under which power supply happens to his parents. One species. Has he put his signature as a witness? Has he subscribed anything to that application?
In fact, by that time, he was minor rulership. His father had taken
That makes
power
your-
connection.
That makes your case still worse. No, brother. How much money it is?
That is, beloved, after review that, after the GRF order and ombudsman order, he submitted an application to
No, that is 2,80,000.
2 lakh. After revision, that was 1,24,000.
Ah.
That is pays the lordship.
One
He has
lakh-
annexed to lordship.
1,22,000.
1 lakh pays 23 lordship.
Yes.
1,24,618. That on the basis of application. After that,
If you pay 50%.
Sir, 1 minute. Sir, 1 minute.
No, we are telling.
How they are claiming that bill 2004, they have 2004 there was no power connection. The power connection was made on a shop that is in the market, that is Hon'Ble market. That was power connection was made, that is over the government land. Since 2004, no one was there. They are claiming how they are charging the electric bill, basing on that direction by the GRF. One inquiry has been made in the year 2024-25. Asked some persons, yes, no one was there in that shop. Shop was closed since long, and the one meter was installed outside that somewhere. Then they have charged the bill. That was the way they are charging the bill. Asking somebody, yes, this is the outstanding, you can charge the bill. Since 2004, no one was there.
Now-
That was the government land, and that was also a market area and a thatched house. And they are charging the bill in the 2004 when the Tata Power Supply also took over the charge. Earlier it was the Sesco. It was Nesco. Nesco was also there. Thereafter the Tata Power and the area of sir.
We will hear this matter
Sir.
when your turn comes.
Yes.
So it will take another 15 years. Instead, pay 50% of the amount. We will direct them to supply. And what will happen to that money? Will the fate of the
Sir, yes,
Agree?
yes.
And we'll keep the petition pending.
Yes.
We'll examine
Sir,
all aspects of
Sir.
it. The essential grievance of the petitioner is against the rejection of his application for power supply on the ground that the parents are in arrears in respect of another premise.
Under the
First
same license.
This presumably.
Market house, one market.
All right, sit down, sir, sit down, sit down, sit down. You are troubling us. Sit down, please sit down. This appears to have been structured in terms of Regulation 17(1) of OERC Conditions of Supply Code 2019, which is held to have statutory force by virtue of Apex Court decision in so and so means.
Not in Apex Court decision, in exercise of power, electricity.
No, Apex Court, we read one paragraph. All they have got statutory force. Next paragraph. Matter requires deeper consideration. Personally. Next paragraph. It has been well settled by a catena of decisions of the Apex Court that the electricity power is the lifeline of the people. First off, ordinarily, the application for grant of supply of power cannot be turned down except on cogent grounds recognized by state. First off, the only ground on which power supply is denied to the petitioner is, as already mentioned, that his parents are in arrears of power supply, arrears of power supply to another premise. First one. Next one. Both the sides now agree that due to paucity of the time, the petitioner should pay 50% of the quantified arrears, and on such payment, the application of the petitioner should be considered without insisting upon the payment of parents' dues. Within parent dues. First one. Next paragraph. In the above circumstances, by way of interim arrangement, the interim arrangement is accordingly made. If they pay 50%, you consider their application without insisting upon payment, etc. There are other things.
Rest part of the money.
Yes.
50% of that, the area of
25 amount.
That you have said.
You have already said 1,20,000.
1,25,000.
You write down that.
50% of that.
4,000 again should not arrears.
That is 1,24,000.
60,000.
680.
680. Next.
Item 17.
Item 17.
Yes, sir.
This similar nature of case has been filed before the Honorable Supreme Court, and European has challenged the same. Nursing will issue notice to the other cases. Issue nursing may and then for outcome or.
That is, your lordship just a glance to last order, that is order 28/1/2026, which your lordship's permission and pressing. Order number 5, that 28/1/2026. Last occasion.
Yes,
My lord.
They have sent the issue notice of application for condemnation.
In SLC, your lordship.
Reasonable in 6 weeks.
My lord. In SLC. So my humble submission, your lordship may dispose of this matter, and your lordship.
It's pending, my lord, because it's.
Suppose if you succeed, we will say, as of now, the order of our court is not stayed. Not even the condonation of delay has been done in your matter. We will say, in terms of that, we dispose of this petition, na?
In the petition, in this case, yes.
Petition, reserving liberty to the petitioner to seek its revival after and on the in terms of their result of this session.
Yes.
Which is that similar matter is?
My lord, that is Gaurang Jana versus Union of India.
The subject matter of this petition is substantially similar to the one in WPC number 5178 of 2025, heard and disposed of by a coordinate bench of this court, wide order dated 17/4/2025. See, that is the Union of India versus Naveen Kumar Senapati. All right, no. Heard and disposed of by a coordinate bench of this court, wide order dated 17/4/2025, dismissing the first time. Next one. Learned counsel appearing for the OPM employee submits
My
that.
lord, I am the appellant here, your petitioner, your lordship.
Here you are. That's one.
My lord.
Yes,
Petitioner.
there were
In another case, your lordship, Gaurang Jana case, that is also similar. They are also employee, I am also. In case of Punjab, I am.
You are similar to Gaurang Jana.
Gaurang Jana, your lordship.
counsel for the petitioner tells us that the subject matter of this case is again substantially similar to the one in Gauranga Jana versus
Union of India.
Union of India. In WP number
WP 37387.
37387 of
2020. My lord.
between Gauranga Jana versus Union of India, disposed of by another coordinate bench, wide order dated 4/8/2025, wherein relief has been accorded to the employees of the kind, and therefore, on the principle of parity, the petition has to be disposed of accordingly. First one. Next paragraph. Learned DSG, assisted by learned CGC, so and so, draws our attention to an order of the Apex Court dated 16/1/2026 in SLP diary number 71634 of 2025, between Union of India and another versus Naveen Kumar Senapati, whereby notice has been issued on the application for condonation of delay. That application being PA number 5984 of 2026. First one, he tells us that when already notice has been ordered by the Apex Court on the delay application, the hearing of this matter be deferred. First off, we do not agree. First off, when already a view is taken by two coordinate benches of this court, then it is not desirable to keep this matter pending any longer, awaiting the decision of the Apex Court in the above SLP, which may take its own time. First, we are of the considered opinion that this writ petition should be disposed of with liberty to the petitioners to seek its revival on the basis of the outcome of the SLP diary number 71634 of 2025. First, next paragraph. Ordered accordingly and writ petition is disposed of without interference. Next.
Item 18, WPC 12462 of 2025.
May I please?
Yes, sir. Mr. Lenka is not seen nowadays.
No, I am court number 9.
Okay.
Here, my lord, the read petition is directed against the order passed by the Central Administrative Tribunal. That is, your lordship may kindly see Annexure 9.
Exer 9.
Yes, ma'am.
What is the subject matter? Can you put
Subject
it in a
matter-
few lines?
Yes, ma'am. That there was an advertisement for the post of psychiatrist, and the essential qualification was essential qualification was for 5 years work experience.
5-year work experience.
Apart from the educational qualification. Then what happened, my lord? The petition, the respondent here, he applied for the post, and at the time of verification, when the offer of appointment was issued, it was categorically mentioned that subject to verification of your documents.
Subject to verification of documents.
That is that I have also annexed.
That work experience also is a document.
Yes, is a document. Prior to that, what happened, my lord? There was a mistake on the part of the institution. When they verified the document, they overlooked that there is a shortfall of work experience.
How much shortfall?
5 months, something else. Then, at the time of when he came to join, when he got the offer of appointment, there it was found that he has replaced another work experience certificate, even if there is also a shortfall. So he approached the Lorraine Tribunal, and the Lorraine Tribunal allowed issued notice, and an interim measure directed to allow him to continue in the post. So against that, we filed review application. That our review application was rejected on the ground that there is a delay. In fact, there is no delay. Even 6 days more was with us.
Only on the ground of delay it is rejected?
Yes, and that review order was made by circulation.
Is it review or recall?
No.
Is it find under order 47 rule 17182?
Rule, the administrative tribunal that is review under section under rule 17(3).
So that is also requires order of 7.
1 second. 17(3) is final order or interim order?
No, interim order. Yes.
Review of is admissible
Yes,
for interim order also?
Yes. And your lordship will find that the order was passed on 6/2/2025. Then we filed a review on 24/3/2025.
Within prescribed
30 days. 30 days was prescribed.
Why tribunal miscalculated the why it miscomputed?
Because it was the order was passed by circulation resolution. By circulation. No opportunity was given to us.
So you could have pointed out if it was heard in the open court.
Yes.
What is
My humble submission is the applicant.
order was made on which day?
Review application, my lord, I concede. Yes. Fairly concede.
Consider the application.
Then the interim order was passed after the person concerned joined for 1 month. The Honorable Court Tribunal's order of
Now,
kindness.
that's all right. We are finding. No,
Review application, my lord, I say. Fairly say.
it is an error apparent on the face
Yes.
of the record.
No, not error. A review is a
Correct.
review may.
We will allow this petition. Remind that application matter
Parity.
for the first consideration.
Parity, yes.
Treating the matter as within the limitation.
Yes, yes.
That will
That's
not
enough,
keep
my
it
lord.
open.
That's, yes.
All right?
Yes, ma'am. In the meantime, they have also initiated a contempt proceeding against
No,
the office.
contempt against the interim order.
Oh, we are not on the result of that review. Entertain.
Yeah, contempt the interim order. My lord, what happens?
Again, you want to argue?
No.
So that we'll take up the matter on very itself. No, we'll take up now if you want to argue.
Government assignment, he left and joined.
Another government.
Yes, he left and joined here
How many
for 1 month.
in
for
that
1 month.
institution? How many posts of psychiatrists? Nowadays, we need more psychiatrists. No? That is Dr. Trehan's report
Yes.
of AIMS Delhi. How many psychiatrists are there? We need lot many psychiatrists nowadays. Their number is very, very big. Not only it is less than required, it is militantly less than what we require.
Advertisement is for 3.
Huh?
3.
Three. How many are appointed? All the 3 are appointed.
The applicant was selected and appointed.
No, he is one amongst three or?
One amongst the three.
Other two persons are also
Yes.
Can we request the tribunal to dispose of the main matter itself?
Yes, yes.
Instead of
Your Lordship may-
everything.
They have taken 4 years to file the account for this.
No,
this
we'll tell them now.
I will file rejoinder there.
You file now, that will give you some time. Within that you make it.
No, kindly,
Now she is agreeable for that.
only my since.
So you want to keep it
No, no.
pending for another 10 years?
No. I
Therefore,
also want that.
we are telling you-
Let the matter be decided on merit. But interim order stands because I have already.
That's what we are telling you. Instead of going for interim order, one hearing, main matter, another hearing.
Yes.
That main matter will be heard by the tribunal within an outer limit of 3 months. All right? Yes.
And the interim order will be operative.
That's fine.
Yeah.
Both the sides having argued the matter vociferously for some time in their own ways, are now graciously agreeable with the suggestion of this court that the main matter in OA number.
Yes.
Tell me.
Way number 335,
335 of
2025.
335 of 2024.
Yes.
24.
335 of 2024.
Pending on the file of Central Administrative Tribunal Cuttack,
Yes, sir.
he finally heard and decided within an outer limit of 3 months. And till that happens, the interim order granted by the tribunal, which is now challenged before us, shall continue. Subject to outcome. First. They also tell us that all contentions of the party should be kept open and that the opponent.
The applicant therein.
It is opponent.
Yes.
You are not practicing.
Will file count. Origin.
Opponent hearing be granted liberty to file his rejoinder to the counter filed by the petitioner's hearing within 2 weeks. First, we agree. Next one. Ordered accordingly and writ petition is disposed.
Review application.
No, that also goes. No review now. Main matter itself should be decided. Now again review. All these years he has been working.
After leaving a government assignment, I
I
am sorry.
left one government.
Your
Where
Lordship.
is your qualification?
MSc.
But that is no requirement. Qualification is not educational qualification. Experience also.
I will.
That we will examine. That
No, that is
tribunal
there, my lord. That is
Take call next matter. You're simply wasting time.
Item 19.
That is a rejection order should be passed. That's right.
No.
Review rejection order should be.
No, it will not be quashed because we have told the main matter itself should be disposed of.
Yes.
Therefore, the question of again rehearing the review matter will not arise at all. Yeah, next.
Item 19, 25049 of 2025. WBC 25049 of 2025.
Yes, Mr. Rao.
The petitioner before our lordships is a housewife, lady, and she is aggrieved against a reversing judgment of the debt recovery appellate tribunal. What has happened in this one?
Is she borrower?
No, she is the guarantor,
Guarantor.
wife of the borrower.
The borrower, but guarantor also.
What has happened? She has got a residential house. Only residential house. And she got it by way of a lease from the Cuttack Development Authority. The lease was in respect of a plot land, vacant land. And as per the brochure, as per the rules of the Development Authority, and as per the terms of the lease, one can borrow money for the purpose of constructing a house, because the purpose of the scheme is to give residence to everybody. The Development Authority has evaluated the scheme to see that everyone is having a residence. So such a clause was there in the lease deed, saying that one can borrow money with the permission of the CDA.
Yeah.
money from the financial institutions for the purpose of construction of the house. Now, an application was made after plot was got, permission was granted, loan was availed. That was a house building loan. Construction was made, and thereafter that loan was also squared off. Payment was made. In the meantime, the husband of the petitioner, who is into a business, who is also arrayed as an opposite party here, he availed a commercial loan for the purpose of running the business, unconnected with this plot.
How much?
That amount, my lord, I think he has availed 35 lakhs.
When?
12/7/2006.
2006?
Yes.
20 years ago.
Well, let me just to complete the chain of events. Then what has happened, my lord? Bank has bank has taken.
Others may not wait. We have 2-3 persons wait next in line. Rest of the people can go for lunch and come back. Yeah. It is open to you to sit in the court hall is another thing.
Lordships are very considerate.
Open court.
Lordships are very considerate for that.
No, because continuously they will be sitting.
Quite correct. Yeah. So then what, my lord, what has happened? See, the bank has taken a document from the present petitioner saying that
Yes.
the mortgage in respect of that plot is extended for the mortgage of commercial loan also. No permission was there, no authority to give loan for commercial purposes is there under the lease deed also. Even then that's the document they rely upon, and they have made a publication for sale of this residential house. Then this lady filed an application under Section 17 of the Securitization Act, questioning the sale by saying that this is for residential purpose, this cannot be leased out, no loan can be availed on this, they cannot sell this property. Then tribunal has passed an order taking into account the lease condition, said that yes, this is a bar in selling the property, and therefore set aside that notice for auction. Then bank carried the matter to the appeal before the Debt Recovery Appellate Tribunal. Then appellate tribunal has reversed it, saying that you having
Given that one.
given a mortgage, you can't come back. That is what the view is. But your lordship knows the judgment of Honorable Apex Court, which says that if such a condition is stipulated, such condition, bank has to see that condition, and if the loan is not capable of being granted, should not be granted. This is the legal position.
That judgment of the Apex Court. You only have done, it amounts to virtually playing fraud on the bank. No.
Same time.
Why did you give it to the bank? That's all for the husband.
My case is valid, I have not given it, but then that's a matter for adjudication.
You having given it, which paragraph?
Your Honor will kindly turn to page 759. First paragraph, ABP mortgaged the property in favor of Union Bank of India and obtained loan. Since ABP became irregular in paying the loan installment, the bank filed a suit in 1990 before the... You're also getting it?
Yeah. ABB mortgaged the property
in favor of Union Bank of India and obtained loan. Since ABP became irregular in paying the loan installment, the bank filed a suit in 1990 before the Calcutta High Court without making the state of UP and the collector concerned as parties.
What is meant by Najul property?
Najul property is a leasehold property.
Leasehold property.
In Cuttack also properties.
Not that way. is it a perceived?
Yes.
Anything? A mortgage decree was passed.
A mortgage decree was passed on the basis of the settlement arrived between the parties. However, when the terms of mortgage decree were not complied with, inasmuch as the decretal amount was not paid to the bank by the mortgager, ABP company, the bank filed an application in the Calcutta High Court for transfer of execution applications to the Debt Recovery Tribunal for issuance of recovery certificates. Upon such transfer, cases were registered before the Debt Recovery Tribunal, Calcutta. Before the DRT Calcutta, a settlement was entered between the parties. Before the DRT, 5 banks and ABP company, mortgager, and guarantors were the respondents. Here also, the state of UP was not a party to the debts recovery proceeding. On the basis of consent of parties, DRT passed an order in 2004. Pursuant to that order, an auction sale notice was published in respect of the property in question. The offer of the company, J, was accepted. J deposited 25% of the bid amount within 15 days, but instead of depositing remaining 75% of the amount as per auction condition, it asked the bank to first get the property converted into freehold or have a transferable right in respect of the said property. Thereafter, a so-called notice was issued by the bank, J, in 2004. In this connection, a writ petition was filed by the company and the High Court stayed the so-called notice. An application was made by the bank for grant of freehold right in respect of the land in question, but the same was rejected by the District Magistrate, Allahabad. In the meanwhile, the state government issued notice in 1998 calling upon ABP to show cause as to why the possession of the property in question be not taken by the government as per the Government Grants Act. ABP did not challenge the notice, but the bank, on the basis of the mortgage decree, filed a writ petition before the Allahabad High Court for quashing the notice. The bank further requested conversion of the property into question to freehold. The state of UP, for the first time after having come to know about these developments, when it was made party in the writ petition, filed a counter affidavit stating that the property in question is Nazul property, which was given to ABP and an account of expiry of the period of lease, and for violation of the terms of the lease, so-called notice was issued for resumption of the property. The case of the state of UP is that proposed decision for renewal of lease was not given effect, and the same was finally rejected by order dated 2005. These are
The facts of
facts of the case. Yes. Now,
Lesser was before the court.
yes, your also sign.
Lesser was before the court. Now, there is one famous judgment by Lord Halsbury, Mr. Rao. There is a famous judgment by Lord Halsbury in 1901, Quinn versus Needham, where he said, a decision is an authority for the proposition laid down in a fact matrix of a case, and not for all that would logically follow from what has been so laid down. Facts are different. Here, couple is here.
Yes.
The husband and wife. And suppose if lesser is aggrieved, let him come. We'll examine in the light of this judge. But not at your instance. You having given the property, maybe leasehold. Leasehold is also a property only.
No, I don't at all stand on the way to that proposition.
Yeah. As long as lease continues, that will be security. Once the lease is determined, security evaporates.
Yes, ma'am.
That's the law.
Yes, ma'am. But here, one paragraph just.
Which paragraph?
Judgment.
In the judgment.
Which paragraph?
Paragraph 41, page 775. At page 775, paragraph 41. In the present case,
775.
Yes.
41. In the present
case, the appellant bank, which is a nationalized bank, before lending public money.
No, that has been reflected in the paragraph. We have read that also.
Yes, yes.
Come to page 2, second page. We have already read that.
Yes, ma'am.
That is only taken from that paragraph.
Yes, two lines which attracted me. I am just placing. In the present case, the appellant bank, which is a nationalized bank, before lending public money by way of loan as against the security of disputed property by way of depositing title deed, was supposed to verify the title of the mortgagor in respect of the disputed property. But neither has any evidence nor a single sheet
That
of
has
paper.
been done. No evidence that it has been done.
They have taken care
It
of.
was in your favor.
They have taken care of that. Now, my lord, you must kindly have a look at the clause itself.
I am in full agreement with you.
Quite.
But there is no reason to doubt Mr. Rao. He is a top member of the bar.
Right.
Why we should doubt him?
Grateful, my lord, for your lordship support.
But that being said, we have fair, very humbly we say, fair degree of knowledge in banking law, more particularly law of mortgages. A leasehold property is also a property.
Yes. Leasehold interest.
Yes, leasehold interest is also a property. It's not said like that. And it protected under Article 300 capital A of the Constitution. It protected leasehold also.
Yes.
Saying that it is a property. There is no power in the Transfer of Property Act to transfer the interest of the lessee, because Section 5 of the Transfer of Property Act defines what is transfer. Transfer of property means to transfer property or any interest in the property.
Yes.
Leasehold is an interest in the property. If that is so, where is this number one? Number two, for invoking this judgment can be invoked by your lessor, not by you.
That's CDA been.
CDA, in spite of my application to implead CDA,
Why they should?
is the owner. Because the CDA is the owner, as your lordships have rightly, it fell from your lordships, that they could very well say that it is.
All will say, is your client ready to make the payment? We will give you some installments. Ask him.
My friend appears for my.
Pursuant to lordships notice, I have appeared.
You are for
the borrower.
You are for the borrower.
Borrower.
Borrower is husband.
Husband.
For my.
Maybe a little bit some difference, that is no problem for that. May I suggest one thing?
Yes.
That I have persuaded my client that you must pay so far the dues of the bank is concerned. And in fact, the bank, the loan amount is about 40 lakhs. 35 plus 5, 40 lakhs.
40 lakhs when? As on?
But you went back in 2007, but till
I have the current.
But it must be in crores.
what I
The
suggest
net dues after whatever payment they have as of 23/3/2026, that was yesterday, is 2 crores 39 lakhs 36,705.
But suppose
Yes.
if the lease determines or lease is terminated, where do you stand?
I'm aware. But one more, since my senior has the state of UP, but was the major difference between that case.
Don't worry about it.
No, the lease had expired in that case.
Once lease expires, your right is holding over, not beyond that.
Absolutely.
A holding over is not held to be a property.
Absolutely not. In both case, the lease had expired. In our case, the lease is
Wait, what do you want? Do you want to go bona
I
fide?
suggest one thing.
Yes.
They say that 2 crores, but as on 2023, they have calculated about 69 lakhs or 70 lakhs with the interest 12%. That is beyond also. That's not a question, sir, because your lordship is not going to decide all this.
Correct.
Your lordship may give me a chance at least to have a talk with Super. I'll deposit some amount.
How
that
much?
also I have persuaded.
Some amount means some is a very dangerous
yes,
word.
They said 2 crores. So it is not practically not possible to 2 crores that your lordship, at least the principal amount is 40. We have paid 10 plus 5, 10 plus 1, 11 lakhs 50,000. Yes, 25 lakhs I have my client was saying that 15 lakhs I can arrange somewhere and I can give it. But I am persuaded him to at least go for 25 lakh. Otherwise, I cannot pursue the honorable court because I know so far this bank is concerned, they must come forward with the. But OTS, if your lordship will suggest the bank to accept, then I'll go for OTS or another alternative. If your lordship will also fix a mediation for this, and I am ready to deposit some the amount here, before the registry of this.
Not registry, to your account.
Yes.
You have taken money.
Sir, that is exactly the problem. Is
why most of the borrowers have become cheats.
The whole problem is, suppose something is failed, then bank will now take advantage of that. That is why I say that if your lordship will allow me, I will deposit the amount, whatever lordship will fix because of this, in this condition.
Now it is 2 crore, how
My
much?
lords, I'll give you the breakup of that amount because I received a.
No, as on today.
My lords, the loan outstanding is 69,67,630. Then accrued interest from 2012 to 2026 is 1 crore 81 lakhs. And that is what, my lord, the net dues payable is 239,36,705.
That's 69.
My lords, I got a statement when I asked them to send me an updated statement.
When the lease is expiring? Tenure of the lease is expiring on which date?
2070.
Huh?
2070.
2070. This longevity gives her hope.
Yes, my lord.
Suppose if the lease is terminated on
My
the
lord,
ground
as
that
Bombay High Court judgment also on
Apex
similar
Court has
facts.
considered this aspect, na?
Yes.
Apex Court has considered these aspects.
In that, the lease had expired before this bank had given the loan. So that is why they said the bank was here, the lease is subsisting. My lords, and it's and that was a commercial high-end value property. This is a residential property. It's a standard thing. One can pay convenience fee.
How much,
convert
Mr.
that to
Ramsarai, before we dismiss, we give an option to your client? How much money you will be able to deposit now? Credit to your account now?
25 lakhs, sir.
25 lakh? No, it is less than 10%.
No, they said.
We have made it, in the morning we have made, Mr. Carr appeared in one matter. It was a MSME, we made it 30%. 30% we made it. Now, of course, it was MSME. Now we are proposing.
If your worship will allow me that so much.
You want to say something?
Because the principal amount 35 plus 540 and paid 11,50,000. The rest amount DRT before the DRT, because the conditional order was passed, I had to pay. So the rest of the amount I can pay are subject to that OTS will also say permit me to.
You will say one thing.
Yes, sir.
For OTS, what is the normative requirement? How much money? 10%.
It will be a compromise because the OTS scheme may not be there. It will be a compromise between the bank and the party.
Same thing.
You want money.
What are we needing?
They want money.
That's all.
The money.
Therefore, nothing comes in the way. When money is going into your
None of it's come.
nothing. You pay 20% of the amount. Okay? And you move the application, OTS application. Let them consider that application. To the extent possible, little lenient, because he is paying more than 10% as a pre-deposit. Your 10% will be, why we are saying this? We are moving little this side, that side of, we are operating on the doctrine of penumbra, that we are on the shadow of the law. Now, let him pay 20% of the amount. You consider his application for OTS leniently, keeping in view the observations made by the Apex Court. This benefit can be taken up by you and to some extent by them also. If they agree to that, very good.
I had no other option, sir. Because I told my client that if you will not get here, you will not get anything.
We don't see.
That's right. I already told my client, whatever is fixed.
No, we will not fix. We will only dismiss on the ground.
Man, 20%.
The court offered this. I am the litigant did not take
Your
it.
worship said 20%.
20% of 2 crores 39.
That's what.
Yes.
20%.
Let that be
Even
clarified.
further than that. At least now, whatever mistakes, whichever is done, well,
Unfortunately,
Can your worship fix up an amount?
yes, I'll fix that.
Fix up this.
That 20% of that outstanding. We have not
39.
undertaken the calculation.
That comes to
Lords, it's 2 crores 39.
no,
It's
20%.
Come to my math.
Mr. Ratho is going out now saying that we are taking
Six.
more time.
I am called in some other court. I thought I'm disturbing your worship.
No, nothing. Challenge is to the coercive recovery action of outstanding amount constituted under the provisions of Surface Act 2002. First up. Both the sides argued the matter for some time and now very graciously agree that petitioner the petition, borrower and the guarantors shall pay collectively a sum of rupees, a sum at the rate of 20% of the outstanding dues within 3 weeks, 4 weeks, within 4 weeks. That is 10% within 2 weeks,
6 weeks.
and 10% within 3 weeks, and remainder in equal percentage in 3 weeks next following, as a precondition for consideration of their intended application for OTS. OTS. And that the bank shall leniently consider the said application, keeping in view observations of the apex court in State of Uttar Pradesh versus United Bank of India, 2016, 2 SEC 757, and in compliance with the extant RBI circulars. Correct? You are bound by RBI circulars?
No, I haven't.
You are not.
No.
RBI circulars.
You have to go by the RBI circulars.
And the bank's policy as well. First, application we made within within 1 week after the expiry of after the payment of after the payment, as mentioned, as directed above, and that till the application is considered and result of such consideration is communicated to the petition, to the borrower and the surety, the guarantor, and also 2 weeks lapse therefrom, no coercive action shall be taken against them. See, they will deposit, they will credit to their account, going to be credited to the loan account. 20% of the amount, outstanding amount. 10%, it comes whichever. You have taken the money, you have pocketed the money.
Figure, I don't know what 20%.
10% within 3 weeks, and another 10% in the next 3 weeks. On payment of that, within 1 week, they should make the application for OTS, and you should leniently consider the application till consideration happens. And you inform the result of consideration, and further 2 more weeks lapse. Till then, you should not take any coercive action against, because they should be in a position to explore.
It has 48 lakhs.
Can I make a request?
Yes.
Let the bank supply the details of
We'll
the
say it now, 48, that becomes 40. Instead of 20%.
47 lakhs, 87.
We'll say 48 lakhs.
statement. The statement.
Instead of 20%, 48 lakhs. Okay, 24 within 3 weeks, remainder in next 3 weeks. All. So that all problems will not be. We'll send it. Ordered accordingly.
Let them supply the copy of the statement. So
You copy of the statement, right?
I'll message him. I'll WhatsApp him whatever I have received.
yes, no.
Item 23. Can it be taken up next week?
You want next week?
Yes.
Next week at the request of.
Well, I am for the petition. With much endeavor, your lordship recalls that it is the regularization matter of State Bank of India. 25-30 years these employees had served. So your lordship said that this matter may be listed immediately after receipt of notice, service of notice.
No,
so it has come up. My learned friend is requesting. I don't have any objection to that. But your lordship may kindly take it up on a shorter date with the top of the list. That is the, your lordship may keep it on 31st. 31st?
On 31st. All right. Yes, 31st. Yes.
Item 2, WPC 554 of 2026.
Item 2 will brought the book. I could
You have
not.
brought the book.
Yes, my lord.
Present it to the
Yes.
library now.
Yes, my lord.
Okay. Where is our library? Here.
Yes, my lord.
You present it.
I'll pay.
You present it. Then we will take up the matter. Yes. Sir. Not
Because-
bringing here.
No,
What is
because-
the order?
My lord, because
Give
the,
it to them. That's
because the secretary was not available, so I could not.
all. right.
Because he
Find
to give the
secretary
receipt,
and
my
hand the
lord.
book. Call it tomorrow. Yes. Sir. Yes. Any urgency, brother?
Urgency, there is a content proceeding that is progressing. That is the
Till
whole
date, next date, till we consider the content proceeding. We'll condone the delay.
Yes,
now.
yes, sir.
Anyway, he has given a book. You also can turn its pages. All right. It's a very good book. Rustomji on
Yes.
limitation. It's the best book, one of the best books. You just go through and we'll call this matter next week.
Tomorrow, my lord.
Tomorrow we have, the calendar is very heavy. Tomorrow. Therefore, next week we will have this. You see, you go and present that book.
Yes, my lord. Right now I will present it.
We'll condone the delay.
No, my lord, there is no delay, my lord.
There is no delay. Why we put this condition to you?
Because, my lord, I asked for time, your lord, put that condition.
My lord, the only I want to mention for some seconds, my lord. This is the,
Why for a second, sir? We'll hear you minutes, sir. On the day, next date when we post this matter.
all right.
Call this matter next week. That's
Specific
the
date
request of the council. It will come one day, this side, that side.
What?
The content proceeding, your lordship.
Till next date of hearing, the pending contempt proceeding shall not be precipitated. All right.
Obviously.
My lord, till next date.
Till next date of hearing.
Ma'am.
No.
Item 4, WPC 8446 of 2026.
Well, in this case, I am challenging the order passed by the Ombudsman Bhubaneswar under Annexure 2. The background of the case is that, my lord.
Now, what is the case?
My lord, here in this case,
Madam appears for, you appear for election.
well, here in this case,
Yeah.
the entire matter relates to electricity connection, new connection.
New connection.
Initially, the property was in the name of IDCO. I am the actual purchaser. I have leased out the property in my favor. And I have mortgaged the property before the bank and obtained some loan. Due to non-payment of loan, the property was auctioned to the petitioner who has filed the application before the GRF.
Yeah.
The auction purchaser has filed an application before the authority for supply of new electricity connection. When the authority did not allow them to provide the electricity connection, he has approached the GRF. The provision is that when one new connection approach for new connection, the pre-required condition has to clear the entire dues of the erstwhile owner or the dues.
Who are you?
I am the erstwhile owner.
Erstwhile owner.
Owner. But the provision is that, my lord, when any applicant has purchased the existing property and connection is disconnected, my connection was disconnected, it shall be the duty of the applicant to verify that the previous owner has paid all the dues to the licensee and obtained no due certificate from the licensee. In case no due certificate is not obtained by the previous owner, the applicant before the purchase of the property may approach the engineer of the licensee for a no due certificate. There was a due, 12 lakh something. As when I purchased the property from others, from the IDCO, I approached the authority to clear up the due, and I have also cleared up the due. When the property is auctioned,
he approached the authority to clear the dues. The authority said that 12,99,000 is the outstanding, you have to pay. That outstanding I have paid the outstanding. And in connection to the outstanding, I have also filed some document for the ombudsman. And I prayed that I am the necessary party. My case, I may be allowed to permit to produce certain document and permission will be given to have a say. He disallowed me my application under Order 10, and as because
10 may not be applicable.
Because
it is not a
correct. The intervention petition was disallowed. So,
brother, hear him also.
He should be heard to avoid multiplicity.
Exactly.
If two parties along with the supply, both of are heard, then everything will
Everything
be
clear.
Yes,
Completely.
admittedly, he was not a party before the original authority was, but,
All right.
but he should be heard.
He should be heard as a matter. Whether the other party is
my lord, main party is electricity department.
No. Here the
applicant is not there.
applicant before the
is the
the present
made a party.
Made a party.
OP number 2.
Notice went to him.
No.
Notice has to go. Issue emergent notice. Learned panel council, Sri signed, so on request volunteers to appear for OP number 3. Emergent notice to 182, returnable within 2 weeks.
My lord, IA is pending for
What for?
my lord, not to proceed with the
Nothing will
my lord, there
Nothing will happen. Nothing will. Yes.
my lord 17 they fixed the my lord.
Yes.
Item 20, WPC 4
Let the notice go on IA.
Yeah. Notice on both main and yes.
Right.
Item 20.
Some other date. No, your lordship, after
What's some other date? Sir is saying some other date.
Lordship, in this case, I have for the adjournment, I have the objection, your lordship. Because
Have you ever seen him asking for time? If he says other day,
some other day means
From morning he has been sitting here.
yes, before 31st, your lordship. Otherwise,
31st. Sir, whichever date you choose.
31st or 30?
30th.
38.
We are filing our IA objection to the IA.
You have to file it in the office. 30th, all right.
Otherwise, the matter would be infructuous.
Solve this matter. Yes.
Well, I am intervener in this case. My lord friend has filed an objection to my intervention application. Can I permit to file a reply with all document, necessary document? Because it will be easier for my lord certification.
Before 30th, you do it.
Yes, I will. Let's permit that. Intervener, my lord.
The intervening applicant is permitted to file his version or counter version as the case may be. It's not this matter.
I have
30th.
taken time for my illness.
I'm sorry, sir.
Because no,
From morning he has been.
I'm sorry.
Yes, I am right from 10 o'clock. I am here.
Yeah, right. You should have told senior counsel saying, sir, you need not wait. Go, because we also told not to wait. At least you should have said,
Yes.
we
Sorry
want
for
to be ready, something like that. You can't keep
we
the
are
senior
ready.
advocates, learned aged people here that
I'm sorry.
that will be ill treatment.
I'm sorry.
They should be respected. Yes. But yes, next.
Item 21, WPC 4679 of 2026.
Yes.
I am a third party purchaser.
Third party purchaser.
Petitioner. And having valid CLDD and also RR in my favor, that which has been reflected page number 35.
Yes.
Page number 36, sorry. Page number 36.
36.
Valid.
Why are you here? What's your prayer? Let us see the prayer.
My prayer is reposition my land which has been kept by bank. OP number 1.
You are third party purchaser
Yes.
from the borrower, directly from the borrower.
Borrower.
When you borrowed it, when you bought it,
When did you purchase?
2023, 9 from 2023.
By then the surface proceeding had already been
the
started.
bank matter was, it was from mortgage to the bank now.
Yes.
When the loan is of each year.
The property was mortgaged.
Mortgage when?
My lord, At the time of availing the loan, the
When it was availed.
Loan was availed on which year or date?
We have to.
But there is no mortgage. But the bank has, OP number 1 has kept the sale deed and it has converted into his side. That is the mortgage deed. But he has never made mortgage deed in sub-register. Because after verification my EC, I purchased the land.
When loan was taken,
loan was taken, my lord.
Turning the pages. Simple matters. A small check, nobody comes to the court with a check. There is no such culture.
May submit.
We are asking you from when the loan was taken.
The first question that you will be confronted from the court is that, and you don't.
When the loan was taken, what is the nature of the loan? How much loan was taken?
Housing loan, 40 lakhs was taken.
When?
Way back in the, that exact date I have not.
Year.
Year?
Which year? Which decade? Was it after Babar came here or before Babar came here? 15?
No, my lord.
After Babar came.
My lord, facts of the case is like this, my lord. The borrower preferred essay before the Honorable Tribunal, which is posted to tomorrow. During the land was mortgaged to the bank. During subsistence of a mortgage, the borrower sold the property to the auction purchaser.
More auction. I have direct purchase. I don't.
No, he is the purchaser, but the land was mortgaged to the bank. During subsistence of a mortgage, the land was property was sold by the borrower.
Where is your mortgage deed? Where is the mortgage deed?
My lord, mortgage deed, it is in the OA, my lord.
You have with that?
No, I have only the essay copy is replied. Tomorrow is posted to the essay is posted to tomorrow. In this case, sale certificate has already been issued and possession has been delivered.
To auction to
the auction purchaser. My lord, I am providing the reply copy. Let's may kind have a glance to the sale certificate.
Sale certificate, you said it. Now we believe you. Should we doubt you?
No.
Then we will not see.
My lord.
We don't have doubt. We don't doubt.
My lord. Fact remains, property was the mortgage to the bank, and during subsistence of a mortgage, the property was sold.
Where is the mortgage deed? So where is the mortgage deed?
Only mortgage deed you have to show.
Lordship,
he's telling that. He's telling no mortgage has been done in sub-register. I am sure if it's sir.
See, if it is an equitable mortgage,
why it is
it will not be registered at all. Only if there is a memorandum of equitable mortgage, it does not have a registration. Unless you show the law. Saying that mortgage has to be registered. Mortgage of that kind. You will not have a case. See, when the original deeds are held by another person, presumption is there is a mortgage of the property for a loan equivalent to the market value of the property. There's some standard books like Mullah on transfer of property, Mitra. They say like this. There are judgments to that effect. So therefore, let us see what happens tomorrow in the DRT.
Lordship, may subject.
You go and get impleaded in the DRT.
I will proceed. I will go to DRT, but may submit some more prayer. The opposite party number 1 cannot took my property unless challenge is the competent civil court through due process of law. First one. Second one is OP number 2. Whimsically arbitrarily passed the 14 section of Surface Act without verifying revenue record, which is not a secured asset. My property is not secured asset.
You challenge that order. Not here. Kindly see section 17. It begins with the word any person aggrieved.
I have already intervened. I have already applied.
We'll tell the DRT to process your application.
And my property is something completely different that properties.
That's what you are saying.
Yes.
We cannot examine all that. Whether there was equitable mortgage or not. How we should examine.
Let's see my ROR.
Suppose if in the ROR, if it is not reflected, you mean to say mortgage is bad? Question of ROR arises where a conveyance, maybe in the form of sale deed, gift deed, exchange deed, or deed of mortgage, or deed of lease, or some anomalous conveyances are reflected in the ROR, where mortgage is by equitable deposit of title deeds. There is no requirement of
Lordship, my principle.
No, why are you
justice
asking us
has
to
been
go-
harassed.
Why are you asking us to see the ROR? What is the purpose?
It does not reflect.
It will never reflect. What is the purpose of ROR?
Right.
If at all. Then why you will see?
See, your section I saw other day, your Land Revenue Act, something like that. It says the entries in the ROR shall be presumed to be true and correct. There is a presumption.
It doesn't create any ownership or extinguishes any ownership.
Absence of entry does not result into a presumption that there is no entry.
No, one more submission. Petitioner cannot deprive from his right to property under Article 300A Constitution of India, state said by the authority of law. At least I should get certain relief because I have purchased that land by moving here and there.
What you have purchased? You have purchased equity of redemption.
How could I know? After verification of EC.
See,
Lordship,
there is a
let me submit.
What you submit without knowing law? Should we go on hearing you till cows come back? That will not do.
My lord, my humble submission, your lordship, may kindly look to the prayer at page 12, where the petitioner has sought for passing of Annexure 5, and Annexure 5 is not issued to the petitioner. So petitioner is no way aggrieved by the Annexure 5. And if at all he is aggrieved, he should have arrayed these his vendors party here. In their absence, this cannot be decided.
You challenge 14/12/25 notice, and order is under section 14 order, which is that dated. Section 14 order has been issued now.
Yes.
That you have to challenge.
I have already intervened in that essay case number.
In essay that 14 order is challenged.
Yes.
Challenge it. Now he also wants to join there.
Join.
Let him join.
Yes. I have no objection.
All right. Then you make application before the DRT if you need any interim relief.
Yes.
We'll permit you. All right. Can we dispose of the matter
Yes, yes.
like this?
Yes.
I think the DIT may not have right to give.
Why?
Because this Hon'Ble Court having inherent power to give some relief to me.
No, we have.
But DRT section 17 gives power to grant interim relief also. Section 17 courts have interpreted that DRT can grant interim relief also. Section right to entertain challenge includes power to grant interim relief. Therefore, together we'll make some observation that way. All right.
No coercive action shall be taken
No,
till the disposal of it.
No, you have to seek that relief there only.
Yeah.
Section 14 is for taking possession of the property.
Yes.
Whether it is sold to any other person, no.
Yes, my lord. That effect to self-certificate has already been issued.
Wrong description of a property. Has
No.
Take on. Petition prayer reads as a. Next one. Learned counsel for the petitioner vehemently argues that his client holds a registered sale deed dated. The pages.
Next 2.
Date we are asking you.
8 September 23.
8 2023, whereby he has become absolute owner of the subject property. And he adds that since mortgage, if any, is not reflected in the encumbrance register, nor in the ROR, there cannot be any income on the holding of his client. First. Therefore, he submits that the impugned order passed under section 14 of the Surface Act 2002 is liable to be voided. to the extent it interferes with the interest of petitioner. Per contra, learned panel counsel appearing for the bank and learned AG appearing for the official OPs oppose the petition contending that already there is a SA number
209 of 2025
pending on the file of DRT Cuttack, where petitioner also has sought for intervention, whether it is application is decided.
No, madam. It is pending. It is. We have already filed our.
And the same has been pending. First, no, they submit that petitioner can work out his remedy under section 17 of the 2002 Act, and he can take up all intentions of the writ petition before the apex, the DRT, before the DRT. Yeah, first. Next, having heard the counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned AGA and also the learned panel counsel appearing for the bank. First, this being a writ court cannot undertake an examination of disputed facts as to there being an equitable mortgage of the security property which the petitioner has bought arguably during the subsistence of the mortgage. First, when a person buys mortgaged property, what he purchases is equity of redemption and nothing beyond that. First, in other words, the buyer becomes the mortgagee. Mortgager remaining the same. First. However, a deeper examination of the matter is not required in as much as that exercise has to be undertaken by the DRT itself, the provisions of section 17 being as wide as they are. First. Next, in the above circumstances and with the above observations, petition is disposed, keeping open all contentions of all parties before the DRT in the SL. No. Next.
Item 22.
The humble submission is that I am repeating for the appellant.
Yes.
From Bhubaneswar, I am appealing due to my health problem. I am not able to present there. My fact is that in respect to the order dated 24 to 26, I informed to the university office to collect the documents of 60 years that exempted from the attendance. So one thing is that after discuss with them, so first the concept of 236. In 236, it means that is attendance. And after attendance and join the regular class, then the second thing is come from the examination which represent for the 237. The 237 is the admission to university examination exemption for an annual or term certificate. It means a provisional certificate and original certificate. First they should have provisional certificate, then next is the original certificate.
Yeah.
Shall I proceed, sir?
Yes, sir.
My humble submission is that the 337 implies that the first point, the name should be registered. The name should register as a student.
1 second, Professor.
Yes, sir.
Order dated 24 February 2026 may be looked into.
Sir.
Kindly read our order.
Sorry, I didn't take out the order. Okay, the order, whether there were any precedents wherein the council, in terms of statute 237, had granted exemption from attendance and issued a certificate to that effect in last 6 decades. I informed them. They are collecting the information. That is, they told that is the near about above 40 years data are there. So they are searching for that. But one thing they say is that exemption in research.
Bring that data. Court wants that data.
Data means the academic council exempted from the attendance. So the last time the issue had been the past informations. This says that, yes, sir.
You bring that information. We'll call this matter next week.
Okay.
Call next week for in compliance of our order dated 24 February 2026. Some judicial officer had appeared examination.
Yes. Let's make a small prayer. Let's say, can it be on 6th? I have 6th of April.
6th?
Yes.
All right. Call this matter on 6th. Okay.
Yes.
How many matters are posted on 6th?
It's 9.
9 matters. Yes, this also you bring it. Yes.
Item 23 has been adjourned. Item 24, Read Appeal 1570 of 2025.
The two read petitions were filed before in one common order. And
one is
disputed now.
All date and other things you have corrected.
Where is that? Corrected one.
Only read petition number.
We changed it. Rest of the thing, IA number to be changed, na? How many years of, how many days? Month?
Dear my lord, delay is 2008.
This to their 9 actually. Here it should be 208, na? IA number? Yes, looking.
A number is my lord 3971.
397.
Yes.
This is 397.
Common order it is.
Common order. Only read petition number to be. This is present read available against the order of read petition number 29147.
Any implementation we have said, any period is prescribed for implementation?
Yes, my lord.
Same.
Yes, same.
Yes, next. Yes, go on.
Item 25, Read Appeal 1779 of 2025.
In item 25,
Waiting for matter.
25.
This matter.
Yes, ma'am. In item 25, 3 matters are there. In one matter, I am appearing. In 2 other matters, Mr. Senior Counsel Subir Palit is appearing. Because of ill health, he has requested me to make a prayer before my lords for a short order.
Recommendation.
He has also requested me.
He has undergone major surgery, major.
Mr. Mohanty wants to say something.
I have to talk to him. I cannot object to it on the health ground, but I pray only that I wanted next week. I want 30 or 31st, my lord, because of first is holiday, and I heard that there is a rumor going on second maybe holiday. So we
will be very happy if that rumor becomes the truth.
That will be a series of days.
So that will be next week, except There will be no working day available. Any day that is convenient to them out of that.
Whichever date convenient to you also.
First week of April, any
Second week of.
Second week of.
sorry,
Second week of.
first week of April.
Where Lordship's observation that your Lordship has not expressed any opinion regarding us. Your Lordship there, you are to state, but the department is not proceeding and
On 16th April, all right.
16th.
16th April. Well, call this matter on 16th April.
for final.
Yes.
Interim order that to continue.
Interim order to continue till then. You want to file counter? Mr. Manti, do you want to file any counter or something?
Read appeal.
Read appeal in fact, na, for the sake of convenience.
Next.
Item 26, read appeal 1852 of 2025.
26 minutes. It is a state appeal. My lords, kindly recall the earlier day, the amount which has been agreed upon, that has been paid. So far the escalated rate amount, that has also been paid. So interest on the escalation. Exactly.
Current rate of interest, interpretation of current rate of interest.
My lord says that if it was awarded at 18, then subsequently it was 9. But in the meantime, I have sought for the instructions, but I could not prepare it. However, I have got the instruction during this, though there is no provision, escalation we have paid. He has accepted it without any objection also, absolutely, and it is within the time. Yes. So far, the other part is concerned, in fact, there is no provision. And apart from that, it is ascertained that this is a bill process. They are working and they are also getting the bill, because it is a tenure of work is 2012 to 2018. Yeah. Subsequently, by virtue of the extension, completed in 2018. Subsequently, amount has been paid. Absolutely, there is no dispute.
Your grievance is only against rate of interest.
Exactly. No, rate
of interest.
No, my lord. The escalated rate, but they are saying interest on the escalated payment, that amount.
That's not true.
I'll explain. Let's escalation is a part of my agreement as per agreement terms. My case is upon completion, they should have paid that escalation amount. They did not pay. I have approached this honorable court in writ once. This honorable court intervened and sent for disposal, and then only they paid in 2021. I am saying in the meanwhile, I have paid bank much higher rate of interest. And I've given proof.
Where are the particular?
Yes.
What are you have paid?
Yes, but yes, let's see the petition. The petition has come.
Yeah.
Let's see, please. Next year 10 million, 46.
How much you have paid to the bank?
Around 17 lakh out of 12 crore, which is around the amount will come around 16%. More, I'm sorry, calculation maths will be more millions. So I am not there. That is not my case, my lords. I am not there. Even if you take SBI PLR, SBI rate of interest, that comes around 9.05, highest rate of interest. That proof, my lords, I'm getting the copy. I just got the information. I prepared it. It's a download from RBI website. That period may be seen, my lords.
During the said period?
Yes, my lords.
What was the highest rate of interest?
10/12/2018. Highest rate of interest was 9.05%. And the Honorable Court has granted me 9%. But it varies. I have to bow down to that. It varies. During period, it varies.
It depends upon the longevity of...
Yes. The highest. So the current rate of interest is highest. Yes. Let me see. Let me see that the observation against 10/12/2018. How they go? That is the period where I start. My entitlement begins for escalation.
is 9.05. The Honorable Court has been pleased to grant me 9% interest, not bank rate of interest.
Yes.
Not what I have paid to the bank. I paid to the bank around 16 or 17%. I'm not seeking that. The Honorable Court has not given that. Only given 9%. Now let me see the observation against 10/12/2018 in the document.
Sir, 10/12/2018. During what period the money should have been, during what date, on what date you ought to have been paid the money?
Yes, my lords. I completed the work
on
my lords.
27/6/2018.
Yes.
27/6/2018.
This is the extended time, my lord.
It is extended.
It has to be completed in 2014.
Now, my lords,
extension was granted at his request. At his request.
27/6.
No, my lords. Extension was granted. They say that there is no default on my part while granting that extension, and say that I am entitled to prices.
Now it became disputed whether he has sought for or we have allowed. But it was admittedly completed in the month of June 2018, though it was to be completed in 2014.
I can provide a document, my lords, that what has been approved, that is approved that I will get the amount with price escalation, and no fault is attributable to me.
Under the terms of the contract.
Yes.
Where are the terms of contract?
Yes, my lords. Terms of contract, my lords. Contract is a petition. Page number.
How all this can be examined by a single judge?
No, my lords.
That's a contract matter.
Yes, my lords. This amount is admitted. Now, amount is admitted. There is no default on the admit. Now, they have paid the amount. It is not that they have not paid, they disputed the amount. So, once they have admitted the amount and paid the amount, can you dispute the interest rate? Whether it has been approved. Now, let me see Honorable Supreme Court. I don't go there. Just I'll place my argument first. Then I'll go to the Supreme Court judgment. Supreme Court judgment says interest once interest is being given as restitution. The courts are not bound by Interest Act. That Miller's judgment is there. Now, Miller's second thing, the court says that the Honorable Apex Court says that when the sum is admitted, interest has to be paid. It gives an example. Saying that scenario, giving a scenario.
No, one second. Learned single judge say from 29 June 2018 payment should be the interest should be paid.
29/6/2018.
Yes. Right. That is the work completion.
Your work is completed on 27/6/2018.
Yes.
On the very same day amount will be paid to you. Which government will pay that?
Yes, Bilal.
There is a buffer.
There is no buffer under the agreement. Yes, that's presumably Millard has prepared very good question. Which government will pay you? But my amount is with them. Yes, may not be paid immediately, but the amount lies with them. They are enjoying the benefit of the amount.
What period? What the terms of contract say within what period to be?
They are silent.
They are silent.
They are silent. That is, they are silent. There are also interest with regard to interest. The contract is silent. There is no. They are saying that I have received it. There is no say that you cannot claim interest. Bills know that railway contracts, there is a bar. Interest on any subject cannot be granted. There is no bar as such bar here. So Millard's bringing in J.G. Roy judgment that you can claim interest where there is no bar. And G.C. Kanunga of our High Court also. G.C. Kanunga judgment that says that interest can be paid when there is no bar. So there is no bar per se. Now Millard's this. Let me see this differently.
No, that appears to be sensible. What you are saying appears to be like Chitti on contract.
Yes.
Yes. Chitti. This is a very famous book.
Yes.
Which often Apex Court has followed.
Yes.
Chitti on contract, Anson on contract, very standard.
And quoted in McDermott judgment. McDermott judgment source says that this can be paid. Now, this paragraph, last paragraph may be seen. Alok Sankar Pandey. Here 12% was granted. When the SBI payroll was 7% by them.
It all depends upon.
Yes, I don't want to buy you. I do not go there, Millers. I just want to show that para 7, Millers. Thanks.
Pay back the principal and the
interest. Now, I have given another judgment which says that restitution, when restitution is there, Interest Act may not be followed. Let me see the Interest Act, that judgment. Last para, page 28 and 29. This theory has now been followed also in the service tax, entity tax matters. Entity tax matters, there is a stay because of the Honorable Apex Court. Now it is being recovered and interest has been imposed.
Restitution in 144.
Yes?
144 CPC.
No. Restitution as
an order or decree reversal by the court. Then restitution. This is another kind of restitution.
This is what?
Compensatory restitution, Millard.
Compensatory restitution, placing the person in the same state which he would have had.
Right.
Suppose if there was
If
no
the
delay.
decree is
Exactly.
Now, Millard, I am not claiming what I have paid to the bank. That I cannot claim. It will be very awkward on my part. I have claimed only the reasonable person. And that court has also.
Anyway, state is in appeal now.
Yes.
Mohanty should also be happy.
Millard may reduce it by 1%. Millard may reduce it by 1%.
Exactly, my lord has pointed out 27/6 war completion. Interest calculated since 29/6 to 37.
I have
the next day.
I have instruction from my client. It will be reduced by 1%. I have to. I understand Mr. Mohanty has also. Let it be.
One day we'll make it 1.5%. Because he has already. See, you have got the work done. It is not your case that he has not.
No, that is not there. My lord, acceleration price also it has been released in their favor. Interest thereupon.
Interest. Because you have delayed. Obviously, these things are delayed.
My lord,
we will not
so
say
far
more
the
than-
delay is concerned, when running bill is there, in day-to-day life it is being paid in phase-one manner basis.
So therefore, we will make it. How much it will be?
It will be 2 crores 70.
No. That is not the amount. 75 lakhs. Total 75 lakhs is the entire amount I'll be entitled to if the order.
Upon 2.
On the amount on 2.79 crore.
Oh yes, only that much
2.79
amount, not the entire contract value. Only on
2.79.
2.79. That amount was due to him. You have paid him also.
Yes.
That we have
Only
paid.
interest
That
on
is
that
the
amount is
escalated.
not paid. That amount was paid 3 years after the contract, after the closing of the contract.
No.
Yes,
It has
yes.
been paid in 2020.
21.
You have
But
applied in
July 2020.
Yes.
applied in 2020 July and not in the name of who is party to the contract in another. Subsequently, this has been incorporated.
The ROC had
Incorporated this.
change of name.
Not that though.
In fact, A. Ramayan Companies Act.
Yes.
He said, change of nomenclature does not bring into existence new entity. The names are changed for several reasons, but entity remains as it is. Once it is incorporated.
Incorporated in the ROC.
Only change. He has produced that material. Well, we remember last date he argued that matter also.
That was in the
It comes with a lot of preparation. We have seen it. And he is very fair also to the court. We will make it 7.5%. 7.25%.
7.5 million. And 9 became 7.
Instead of 9, we will make it 7.25%.
May be permitted to take I can give the details, chart and instruction.
What chart? In fact, I have examined this matter. He is entitled to at least because Justice Dalavir Bhandari's judgment is there. Where transaction is commercial in nature, then commercial rate of interest is applicable. This is a commercial transaction only. It's a commerce. He borrows money from the bank
At escalation also we have paid, not that this has not been paid.
But after how many years?
Well, only 2 years gap is there.
2 years is a long period for a businessman like him. Nobody will come forward for doing
This
the
is in
government job. That is the reason people are hesitant.
Because it is a state interest, can it be considered further, my lord? That can be my humble submission.
Cannot be. In fact, there is no interference at all in matters like this. Right now.
That's me. I don't want to re-agitate. 7.5 may be made.
Because nowadays, the rate of interest all over the world
is declining.
Globally, it is declining.
Globally.
Since last fortnight
has not been looked into by the learned single. Only to that extent. It's a minimum error theory. Minimum error. Therefore, minimum interference. Right now. State and its functionaries in this intra-court appeal seek to call in question a learned single judge's order dated 21st part, 28th of June 2025.
This is order dated, my lord, 26 2025.
20 June 2025, whereby respondents WPC number 6634 of 2023 having been favored, relief has been accorded to them as under. Last paragraph. Next paragraph. Learned AGA, Mr. Mohanty, in his usual submits that when disputed facts were involved, the learned single judge ought to have relegated the parties to the civil litigation.
Commercial Courts Act also.
Under the provisions of Commercial Courts Act 2015. Semicolon. Secondly, learned single judge grossly erred in awarding interest at a high rate of 9% per annum on the amount of rupees 2.79 crores for the period between 29 June 2018 and 30 July 2021. First, he also tells that the period of 2 months prescribed by the learned single judge for making the payment was very short. First, so submitting, he seeks intervention of the court. Per contra, learned counsel appearing for the respondent. How many respondents? Only one respondent?
Yes.
Appearing for the sole respondent. Resist the appeal, contending that the same is not maintainable. Semicolon. The rate of interest prescribed by the learned single judge is perfectly accords with the rates that obtain in the commercial transactions of the kind, and therefore the learned single judge has rightly prescribed the interest as the current rate of interest. Semicolon. There is absolutely no dispute as to the delayed payment of the amount, and therefore it is not a case involving disputed facts. First, so contending, he seeks dismissal of the appeal. Next one, kindly be seated. Having heard learned counsel from the parties and having perused the appeal paper, we grant marginal interference in the matter as under and for the following reasons. Number one, the first contention of learned AGA as to the involvement of disputed facts does not impress us. First, admittedly, the work has been accomplished by the respondent within the extended period with no fault lying at his threshold. First term. Merely because disputed facts are involved, comma, a writ court cannot send a scrupulous litigant back home empty-handed. First term. Oliver Wendell Holmes in so and so has observed as well. It's a very famous judgment by Oliver Wendell Holmes of the US Supreme Court, where he says, a writ court cannot send back the litigant by quoting jurisprudential theories. They come here for a grievance, not for maintaining constitution. Very beautifully has said that.
And this is perfectly reflected in this code also.
We do that frequently. Science, just quote that. Next point. The principle of disputed facts cannot be stretched too far. First of all, the question is not whether there are disputed facts, but whether the facts that are disputed can be ascertained from the material on record. First of all, if dispute can be resolved based upon the evidentiary material on record, comma, writ court cannot shun away from discharging its duties. First. Next point. The fact, the essential fact matrix is that the petitioner has accomplished, the respondent being the contractor has accomplished the task within the extended period with no complaints whatsoever. First number. The work was accomplished on 30 July 2020, 27/6/2008. Is not in dispute. First one. It is also not in dispute that a sum of rupees 2.79 crore that was due to the respondent was remitted to him belatedly.
It is my lord after deduction. Because 2 crore 18 and after deduction 270.
Of course, this was after deduction of taxes and levies. First one, whatever that be, comma, the delayed payment has to be accompanied by interest. First one. One should have interest to pay the principal, and nobody should say that it is his principal not to pay the interest. First of all, the impugned order is animated, inarticulately animated, that is it. First of all, therefore, levy of interest as such cannot be altered. Next paragraph. The above being said, the rate of interest appears to be a bit higher, keeping in view the global trend towards declining rates of interest on the deposits, money deposits. First one. This aspect somehow has escaped the attention of the learned single judge. First, had he adverted to that factor, comma, in our considered view, he would have awarded interest at the rate of 7.25%. First, accordingly, we downwardly revise the rate of interest from 9% to 7.25%. Comma, keeping all other things in the improved judgment intact. First, next paragraph. Ordered accordingly and writ appeal is disposed of. No parts. The Wipro versus Commissioner of Income Tax. Take out that judgment. One particular quotation in there. No, not Davis. That is the Holmes. Wipro, where the government said, our principle is that no interest should be paid. And by paying the interest, our interest will not be served. We have said that one. We have got that. Yeah.
Supplemental list is all. Supplemental list is all.
No one. Another one matter, there is a little health issue with me. Small matters, one or two matters.
Item 1 is a very small matter.
Come.
Working list item 1, date of 82 of 2024.
G is also not
yes, none. I have talked to him. I have given the document also.
That's only one prayer. In that application, time frame may be mentioned. Because for compliance time frame, within 7 days or 1 month.
In the event, the interest component shall be the altered, the interest component at the altered rate shall be discharged within an outer period of 6 weeks.
6 weeks.
6 weeks.
That will be 2 months.
All right, 8 weeks.
No, the content is on.
They may not specify the same because
Failing which, the interest awarded by the learned single judge in terms of the impugned order stands revived.
Much.
The rate of interest.
Much.
All right. This will help you much. Yes.
My lord, that's because it is his appeal.
It's my appeal. The thing is that the sole ground in the appeal is learned single judge has directed us to give appointment to the doctor. My lord, unless and until the recruiting agency is the PSC, OPSC, he recommends. We cannot give. That is the sole question involved. If he will give, then we can give.
Before they file the writ appeal, the OPSC has my learned is appearing. They have already recommended my name. So their writ appeal doesn't stand here. And I have given that document.
We have not challenged the order of the learned single.
Kindly have a glance to that.
They have not challenged.
Yes.
We have complied with the order of the learned single just to recommend the name.
I have given one document, that their document. Kindly have a glance.
He's saying that.
Yes, that document I have given.
We don't doubt unnecessarily. Unless there is some doubtful character. Generally, we will not.
Yes, before filing the writ appeal, that was complied. So therefore, this can be disposed of by honorable single. I am an assistant professor. On ad hoc basis, I am continuing in 2015. I am to get the regular appointment only. That is the other.
You have been working as ad hoc lecturer now.
Assistant professor.
Assistant professor.
Yes. Now he has been. Sorry.
You're presently working as what?
Presently, my lord, they have allowed me to function as an associate professor in surgery. In Puri Medical. But I am claiming, because as per the direction, I am to get a regular appointment as an assistant.
Still in ad hoc.
Still in ad hoc.
Associate also in ad hoc.
See, could a higher pay rate, they have adopted a new principle in order to meet the AICTE norm.
You joined as assistant professor.
Ad hoc.
Ad hoc. And now
I am selected for appointment as a regular assistant professor.
No, not promotion.
No. It's an appointment. Yes, but what they to mitigate their own problem, they have allowed me to function as an associate professor in surgery because they have to meet the AICTE norm to have the staffs and all these things. So I am discharging that duty also. From 2015, he has been working. Now he has only been directed by this honorable court because I have selected.
Associate professor position is a promotional post of assistant or not?
Associate is a promotional post of assistant professor. But they are now allowing me to
work on ad hoc basis.
On ad hoc basis. And I am also, so I am to get the assistant professor post now by virtue of this judgment. And on a regular basis.
What the learned single judge has said?
Honorable single judge has said that because the recommendation has initially recommendation was made by the OPSC, it was withdrawn. That withdrawal order I have challenged it. Thereafter, my lord, the honorable court interfere with and direct that OPSC should recommend my name for appointment and government will recommend. Now, OPSC has also recommended my name way back in 5/6/2023. But because of the writ appeal, government is not giving me the appointment. That is the only issue.
Because after the initial select list was prepared, state government requested us to provide a waiting list. So, we recommended a waiting list wherein there were 11 names. Then state government told us, no, you please kindly withdraw the waiting list. That is when we withdrew the waiting list and several writ petitions were filed. Some persons have already been granted appointment on the basis of that waiting list.
On the basis of waiting list
Yes,
itself.
my learned senior is also one. He is also one of the continuing.
But I didn't get it because of the question came late.
Page 16 of the writ petition may kindly be seen. It is clear there. 3.1. That is, yes. Page 16 of the order, my lord. Order passed by the learned single judge. It is contended that during pendency of WPC, so and so.
Impugned order starts at 14, annexed 2.
Which paragraph, Mr. G?
3.1. It is contended that during pendency of WPC number 282 of 2016, the Commission issued a fresh notice on 17/10/2017, wherein the Commission recommends the names of 11 persons in order of merit for appointment to the post of assistant professor in 7 disciplines. In the said notice issued on 17/10/2017, name of the present petitioner finds place at serial number 8. It is contended that when from out of the said list issued on 17/10/2017, the person placed on and at serial number 7 after
SCO withdrawn at the instance of the government.
Of the state government. That document is there at.
Why state government asked it to withdraw the additional list, waiting list?
But it will be clear from annexure 4, page 21.
There 4, page 21.
Yes, ma'am.
What it said?
That state government told us that there were certain matters pending in Supreme Court. The earlier decision in YV Rangaya case, that was being followed. There was a issue before the Honorable Apex Court.
Is it Andhra Pradesh?
I believe Karnataka. Yes, ma'am. That judgment has now been overruled. But the principle there was the rule that has to be followed is of the year the vacancy arose.
Correct.
Well, it's now, there was a rule in 2009, then there was a rule in 2013. The question was whether which rule will apply to which. So there, the Honorable Apex Court said you follow the principle of
the rule, this rule which is coming to force after the accrual of the vacancy has to be followed.
The rule which was present on the day the vacancy arose.
That's fine.
Yes, that prevailing.
Yes.
Today, Rangaya has been overruled subsequently by Justice Narsimha's judgment in state of Himachal Pradesh versus Rajkumar. But in this respect, at least the Honorable Apex Court for the state of Odisha, in respect of this case, the judgment was that you follow Rangaya.
In one of the case of our High Court gone out to Supreme Court of this advertisement, there also Honorable Supreme Court has said vacancy as per 2009 rule or 2013 rule that is to be followed. Prevailing date. What it has been stated in again.
Which obtained as of the date of accrual of vacancy.
Yes.
That should hold
that should hold the field. That is the judgment in our Odisha case, civil appeal number 6157 of 2015, Subhash Chandra Behera's case, in the respect of this particular.
So because of that confusion,
this thing was
yes, therefore state government decided to do everything afresh and they recommended to us to withdraw the waiting list.
What is the wrong with the order, Mr. G? Now that will be restored.
My lord, that is what Mr. Das says. That has been restored, my lord. They have already recommended. Yes.
5623.
They have already recommended. Then
the only thing appointment is
recommended since 2023.
My lord. Yes, that document I have given. 23 man. 5623. Last page of that document also 26. I have given one.
Anyway, and he has been working
Yes.
Yes,
Till
yes,
date, I
sir.
will.
Till date, he is working.
Yes,
He is working till that.
As an associate professor,
In a higher post.
surgery
Higher
on ad hoc basis.
On ad hoc
Yes.
basis.
Now he will be given the regular post of assistant professor,
professor.
which will be lower in grade
Yes.
actually.
But that is different.
Assistant professor.
Surgery.
Lower
Lower post.
Because assistant professor, then associate professor,
associate. Thereafter professor.
then professor,
Yes.
then professor emeritus. These are the categories.
Three tier.
This is all 3 tier in Odisha.
Three tier.
Can be seated. State and its officials have preferred this intra-court appeal. First up, they call in question a learned single judge's order dated 2/5/2023 entered in respondents WPC OAC number 853 of 2018 and another is also same. Yes, WPC OAPPC number 282 of 2016 whereby a direction has been issued to the OPSC to recommend name of the respondent for the post of assistant professor of surgery, coupled with a direction to the petition appellants to issue appointment order in terms of such a recommendation. First of all. Next paragraph. Learned counsel for the appellants, learned AGA appearing for the appellants submits that earlier the OPSC had sent the waiting list at the instance of the government itself. 7. However, because of certain litigations that were fought at the level of the apex court, the UPSC was directed to withdraw the recommendations, the select list, waiting list. Waiting list. And accordingly, it did it. First time. Power to issue a direction would also include the power to recall the direction and to do and to undo what has been done pursuant to such a direction in view of section 21 of Orissa General Clauses Act 1856. No. Just look into it, may not be. I'm not sure. Word central legislation is 1897. 1937. Right. 1937. This aspect having not been considered by the learned single judge, there is an error of great magnitude warranting interference of this court. First, next one. Learned
that will be rule 22. 21 is central act.
Section 22.
Here, Odisha.
Section 22. Okay. Rule or section? Section. Yeah. Learned counsel representing the respondent employee candidate, respondent candidate, and the learned senior panel counsel appearing for the OPSC. It's not senior.
Just panel counsel.
Panel counsel appearing for the OPSC. No. Learned counsel representing the private respondent vehemently opposes the appeal, contending that the principle of Section 22 would not be applicable in matters like this, semicolon. The government itself had directed the OPSC, and accordingly, the waiting list was prepared and submitted. Semicolon. Abruptly, the government could not have turned around and instructed the OPSC to recall the waiting list, quoting certain untenable grounds. Full stop. He also tells that his client has been working as an associate professor of surgery on ad hoc basis, and justice would have been caused, served to him by virtue of impugned order of the learned single judge. And therefore, regardless of arguable infirmities in the impugned order, this court should not interfere. First, learned panel counsel appearing for the OPSC maintains equidistance from both the sides and tells that his client has already submitted the waiting list in terms of the impugned order to the government. First, next one. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter in as much as it is the government which had directed the OPSC to prepare and submit a waiting list. Semicolon. This was done. First, all of a sudden, the government could not have turned around and recalled its instruction to the OPSC, which had already acted upon such instruction. First, in such a situation, we are not sure if the rule underlying Section 22 of 1936 Act, 37 Act, would be readily invocable. First one. Next one. That apart, ours is a government by rule of law. And therefore, all its actions should be animated by reason and justice. Reason, justice, and fair play. Arbitrariness being anathema to the rule of law. While E.P. Rayappa versus State of Tamil Nadu, AR 1974 SC 555. First up, the reasons assigned by the government in instructing the OPSC to recall the waiting list are not germane to the issue. First, therefore, the action of the government is government being vulnerable. Learned single judge has rightly interfered with the say. Next paragraph. Learned counsel appearing for the private respondent is right in telling the court that his client being fully qualified, absolutely qualified, has been discharging his duties as associate professor of surgery of course, on ad hoc basis. First of all, the experience which a candidate like this has acquired in the course of employment, has its own advantage in public service. Public service, first time. It is not that he is trying to be made associate professor of surgery on regular basis. If the impugned order is implemented. First time. What he would get would be the post of assistant professor on regular basis. First time. Thus, even equity weighs with the said respondent. Weighs with the said respondent. First time. All this is inarticulately weaved in the impugned order.
In SC category? In SC category?
He's a SC, but selected, recommended against the UR. Because he is SC. He's a civil caste, but recommended against the UR.
Against UR. Then caste will simply significance. In the above circumstances, this appeal being devoid of merits is liable to be dismissed, and accordingly it is, costs having been made easy. First of all, the impugned order of the learned single judge shall be given effect to in letter and spirit within an outer limit of 6 weeks. Appointment order, that's all. 6 weeks. So, telling which the appellants run the risk of contempt action. Yes.
Only one. It might not consider his case from the date the others have been given appointment. Pursuant to this advertisement, you will have the entire years of service will go. You will not get any financial benefit, notionally only. Because 15 advertisement. He has been fighting out litigation from tribunal to this court and today before money.
What you say appears to be sensible, but without monetary benefit.
Yes, no, I am not claiming
Financial benefit will be.
Plus, one more ground. Learned counsel appearing for the private respondent is more than justified in submitting that, in contending that his client should be given notional benefit of retrospective appointment with the effect from the date
17-10-17, the recommendation.
With effect from
17-10-17.
His counterparts in that page.
First
effect from 17-10-17, 2017. That is the date on which
first list was
the first recommendation of the OPSC was acted upon.
Yes.
When the appointment order.
Upon what that immediately it is given from that date. Uma Prasad Party, the first man from serial number 11 in that list.
When appointment was issued to him. With effect from that date.
Uma Prasad Party,
with effect from that date. First of the appointments was made pursuant to OPSC selection, the select list dated 17-10-17. First time. He is fair in telling that in submitting that his client would not lay a claim for any financial benefits of notional service, of the previous service. First time. We agree with this. First time. Whatever above circumstances, signed some order of 2022. We signed in letter and spirit. And what you say? Within 8 weeks. Keeping in view our observations herein about it. Herein which? Sorry. We have
Item 2,
Which is that?
Writ Appeal 1550/2024.
Yeah. Yes, Mr. G. Not well. Tomorrow. Tomorrow. But
State appeal. It is in the 209 list. Can I pray for tomorrow? Because Thursday contempt proceeding has been
shifted to tomorrow.
209. State appeal.
Yes. In Delhi. Yes.
Okay.
How many matters are posted tomorrow? 28. Tomorrow is not possible.
List since rehabilitation,
Have it on 6/4. 6/4.
7/4, man.
7/4.
7/4.
Not 7/4. Yes.
Item 3, Writ Appeal 1627/2024.
Yes,
Yes.
And I item number 37.
37.
It's a small matter also. To apartment. And the also is to continually delay.
Payment of
And that day, my lord, friend appearing for the state agreed that it should be had on the next day. Now it has gone at least 1 month in between, 1.5 months in between.
which is your matter, brother? Serial number?
Item not 3, man.
3. You have this, then you will have it. Oh, wait. Yes. 3.
It's also a state appeal. Can tomorrow we will do.
Now, we'll have it on 7th.
It's a small matter.
Small matter.
Small matter.
Now, put it tomorrow.
Well, it is in the weekly list. Automatically it will be there. No need to go for rescheduling the date.
You need not fix
It will be there. Automatically.
Mr. Monty was saying one.
Can it come in the supplementary list tomorrow?
Let us see. It's already in the list now. Wait.
This is in the list, Milal.
It is in the list only.
This will continue.
That's what. Next.
Item 4, Writ Appeal
18. Mr. Monty.
1844/2024.
Mine is item number 37.
20?
37.
37. Sir is also waiting now.
It's a stick.
Yes, sir.
Sorry.
The appellant, state appellant, tomorrow. Let it
He is
remain
not
in the
well.
list.
D is not well.
Let it remain in the
On
list.
30th we will have this.
Milad, it is in the list, Milad.
I said let it go on like
Let
this.
it
Go on.
continue.
All right. You are right.
Continue.
This matter is also by state.
Next
It's a
matter.
state appeal.
State appeal.
Mr. Mahadev, it's a state appeal.
It's a state appeal.
It was condoned. Delay was condoned.
Delay was condoned.
Understanding that it should be heard very next day, actually. I remember.
So,
Yes, who appears for
37.
37.
37 allotted to whom?
Mr. Man, 37 to me. Tomorrow.
Ready?
Tomorrow.
All right. Mention it tomorrow.
Progress.
Another item is item 18. Maybe is waiting to see the equivalent of the homeopathy medical sector.
18.
18.
That is my appeal. Well, yes,
They are both better that I mentioned.
You are ready in the matter?
I'm ready now.
Can it be taken up tomorrow?
Tomorrow? No, we can't say tomorrow. It will remain as Mr. Monty pointed out. It will remain.
It will continue, my lord.
It will circulate that.
Even if no mention of it.
It may not reach any day in the supplementary list.
Don't lose hope. We live by hope, na? Somewhere justice will be done that way.
Because it is recruitment matter that you have.
Let's see. with your permission, we are raising, we have many orders to draft. In fact, by the time we go home, it will not before late. 214. Electricity matter.
It is the MSME matter, execution case is pending, your lordship was pleased to pass the interim order of stay. The next day when it is listed, subsequently after notice, the interim order could not be extended and the executive court is proceeding and wanting the.
Earlier there was interim order.
Extension, yes.
Was it conditional order or unconditional order?
No. Order of the MSME is stayed because the executive court is there, it will be hard. There is no conciliation and compromise impacted in the MSME proceeding.
Who is your opponent?
Your
In
opponent.
absence, we cannot continue the order. If you were to be here,
Who is the other side? No, electricity, who is the other? You are elected.
No, it's
MSME.
Item 5 minutes, maybe tomorrow it will be
You mentioned it tomorrow.
Item 5 maybe minutes, we commence on 6 minutes. 7th.
7th. How many matters are question?
10, sir.
10 minutes. Put it on.